Next item of business is consideration of business motion 22515 in the name of Graham Day on behalf of the Parliamentary Bureau setting out a stage 3 timetable for the Children's Scotland Bill. Could I call on Graham Day to move this motion?
Moved, Presiding Officer.
Thank you very much. A point of order from Bruce Crawford.
Presiding Officer, I feel I recognise that we've been discussing very important matters in the last moments, but for the purposes of understanding what the likely conclusion time will be this evening, we're now over 30 minutes behind what the expected timings were. Can I take it we will now be concluding business, we will not be concluding business now before 7 p.m?
It's difficult to know, Mr Crawford, at what time we'll conclude. I allowed topical questions to run on today. There was a huge amount of interest and partly to see whether or not that would resolve the need for a statement on the subject of care homes, which I'm sure members would appreciate. Although we timetabled for a 6:30 decision time, our expectations when we looked at this matter actually was that we'd come slightly under that. So although we are now behind schedule, there is still a prospect of finishing at 6:30. And I'll be honest with you, it's up to members and ministers in terms of the length of contribution as to how long this debate will last. So I think we should still aim for 6:30 rather than 7 expectations. Now, Graham Day has moved the motion. It was on the point of order of the timetable, so the question now, therefore, is that motion 22515 be agreed. Are we all agreed? Yes. We are agreed. So we're going to move on now to the next item, which is stage 3 proceedings on the Children's Scotland Bill. Members should, both here in the Chamber and online, should have with them the bill as amended at stage 2, the marshalled list and the groupings. I should say that the division bell will sound and proceedings will be suspended for a short technical break, which will be 5 minutes or possibly slightly longer. For the first division of the afternoon, that's the only technical break we will have today, so there will be no technical break at decision time. The period of voting for the first division will be 30 seconds. There will be 1 minute for the first vote after any grouping from then on, but 30 seconds for most votes. So members should now refer to the marshalled list. And I call Group 1 on the voice of the child. I call Amendment 8 in the name of the Minister. Grouped with other amendments as shown in the groupings, the Minister to move Amendment 8 and speak to all amendments in the group.
Thank you, Presiding Officer. The amendments in my name seek to strengthen the bill to ensure that the child's views are heard in family court cases and in children's hearings. I wonder if
the Minister could just move her microphone slightly towards it.
Okay. And this, of course, is one of the key aims of this bill. These amendments do two things. Firstly, they reinstate the requirement that children must be given an opportunity to express their views in relevant proceedings. And this requirement was included in the bill on introduction, but was partially replaced at stage 2 with a requirement for a decision maker only to seek to make reasonable arrangements for a child to express his or her views. Secondly, the amendments ensure that where a child's views are sought, the child's preferred method of giving their views is to be used unless it's not reasonable to do so, or the child has not expressed a preferred method of giving their views. These amendments cover family court cases and other proceedings under the Children's Scotland Act 1995, children's hearings, exclusion order proceedings and permanence and adoption cases. And I want to return to a point that I made at stage 2 about exceptions. The Scottish Government believes that the majority of children are capable of forming a view on issues that affect them. But we recognise that this will not always be true in every circumstance. And so for that reason, the bill provides that a decision maker is not required to seek or have regard to the view of a child if satisfied that the child is not capable of forming a view. But the government does not, however, expect this exception to be used frequently. There is also an exception to the requirement to take the child's views in the child's preferred manner because it may not be reasonable in some circumstances to use the child's preferred method of giving their views. And again, I would expect this exception also to be used infrequently. In terms of the ways in which a child can give their views, I've recently published a paper on this and I've committed in the Family Justice Modernisation Strategy to producing guidance for parties on going to court. And this guidance will include information on the range of ways a child can give their views. And of course, we will need to reflect on how the strategy and the guidance are working in practice. So I welcome Amendment 48 in the name of Liam MacArthur, which requires a review of the impact of the Act after 5 years, and I would ask members to agree to that amendment. I am, however, unable to support Amendment 35 in the name of Alex Cole-Hamilton. Amendment 35 would require a person who does not have parental responsibilities and rights, but who is making a decision to safeguard the health, development or welfare of a child to seek and take account of the child's views on maintaining personal relationships with family members. Even if the decision was unrelated to contact and residence and is about something like consent to a medical procedure. I can't imagine that this is what the member actually intended. The bill, of course, makes provision requiring the views of the child to be considered in a variety of contexts, and so it's entirely unclear why the member is seeking to make a change in this specific context only, and doing so would create inconsistency with the rest of the bill and inconsistency for children in the way that their views are obtained. I'd like to reassure the member at this point that the bill allows the views of children to be taken into account in a wide range of circumstances, and that where relevant to the decision or to the case in question, the child's views on their wider family relationships would be sought and would be taken into account as part of that process. And in addition, the bill also requires the court, when making an order under Section 11(1) of the 1995 Act, to have regard to the effect on the child's important non-parental relationships. So I would ask the member in this case not to press Amendment 35.
Thank you very much. And I call Alex Cole-Hamilton to speak to Amendment 35 and the other amendments in this group.
Thank you very much, Presiding Officer. At stage 2, as the Minister and the members of the committee will recall, I did not move my amendments to the bill which sought to include the child's right to maintain personal relationships with the child's lineal ancestors. My constituents, Gordon and Shona Marie Mason, have done a lot of work on the rights of grandchildren to maintain contact with their grandparents. They and I listened to the arguments raised against the stage 2 amendments, and notably those included that the bill does not specify grandparents in particular, because that would exclude other relationships. The right of a child to have contact with their grandparents would have substantially the same implications as the right of grandparent to have contact with their grandchildren. We've taken these arguments into account and now submit an amendment to Section 6 of the 1995 Act, which is entitled Views of Children. This section has already been amended through the course of Stage 2 of this bill. The proposed amendment clearly focuses on the child. It focuses on the maintenance of personal relations with family members and is not thus not restrictive. It makes no mention of grandparents and therefore cannot be construed as giving rights to grandparents, and it states that the action has to be practicable and in the best interests of the child. Familial relationships can be beneficial to the child's health, development and welfare, which are included in Section 1 of the 95 Act, entitled Parental Responsibilities. In Section 6 of the 95 Act, a parent must have regard to any views expressed by the child, and the proposed amendment is intended to cover all situations where the child wishes to express a view on familial relationships. Under this amendment, the child can therefore express their view at any time, even when their parents' relationship is continuing and there is no referral to court proceedings, say under Section 11 of the 95 Act, uniquely upon which the Family Unit issued memorandum this month called Children Giving Views. That is, concluding on this note, Presiding Officer, that is one crucial and distinctive point of this amendment. A parent or parents in an ongoing relationship who through spite or a grudge or through other non-justifiable reason will not allow the child to maintain personal relations with a particular family member or members will still have to regard the views expressed by the child where the maintenance of such relationships is not against the best interests of their child. It's all about the views of the child, only the child, at any time. I have listened to the arguments of the Minister. I will listen to the views of Parliament. If there isn't a majority for it today, then I will withdraw it. But it is an argument I will seek to return to in this place. Thank you.
Thank you very much. And I call Liam MacArthur to speak to Amendment 48 and the other amendments in this group.
Thank you, Presiding Officer. As we start the session, as I've done throughout the committee's scrutiny of the bill, I'd like to remind the Chamber of my interest as my wife is a Director of Relationships Scotland Orkney. This is perhaps less relevant to this set of amendments, but I thought it would be helpful to put this on the record at the outset. Presiding Officer, at stage 2, I was pleased to get support from the committee for my amendment to create a duty on Scottish ministers to ensure the availability of child advocacy services in Section 11 cases. This followed powerful evidence heard by the committee about the need to strengthen the so-called infrastructure for taking children's views. In their written submission, Dr Morrison, Dr Friskney and Professor Tisdale argued, and I quote, "The strongest and most consistent request from children and young people in Scotland who have been involved in contested contact proceedings is to have a child support worker. Without addressing this now, children's participation throughout the legal process risks being dealt with inconsistently on an ad hoc basis and thus marginalised. We recommend provision be put into primary legislation with the ability to then link developments to other advocacy roles." That amendment was passed, but I held off pressing another amendment relating to a proposed review of children's ability to participate in the decision-making process. Of course, reviewing legislation to check it actually does what it's intended to do is generally a good and sensible precaution. However, given the concerns expressed about the resourcing of the provisions in this bill, I think there's a particular need to provide some reassurance to stakeholders that this review will take place and look specifically at whether or not it has facilitated the participation of children in decisions made about their future. As Scottish Women's Aid said ahead of stage 2, quote, "Monitoring and review of the bill's implementation is required to ensure that children's rights are realised in practice." There was support for this at stage 2, although some concerns expressed by the Minister about the proposed 3 as opposed to 5 years in my amendment. I have reflected further on this, and while I remain a little concerned that 5 years opens up the risk of an entire session of Parliament coming and going before any assessment is made, I believe Amendment 48 provides safeguards against this happening. It's perhaps not perfect, but I'm confident colleagues in the next Parliament can and indeed will keep ministers' feet to the fire. Meantime, I'm grateful to the Minister and her officials for their engagement on this issue. Thank you.
Thank you very much. And I call Liam Kerr to be followed by James Kelly.
Thank you, Presiding Officer. I remind members that I'm a practising solicitor holding certificates with the Law Society of Scotland and with England and Wales. We will be voting for all amendments in this group with the exception of Amendment 35. As with the members' amendments throughout stage 2 of the bill, Amendment 35 is clearly well-intentioned, but in reality, I'm not persuaded it would serve a child's interest in the way the member believes it will. Firstly, a key pillar of this bill is that it seeks to improve a child's opportunities to provide their own views whenever possible. My concern is that by emphasising the importance of the child's views on their personal relations with family members, this amendment risks positioning those views as being more important than any other views the child might wish to express. My second concern is that, as with other amendments we've seen at stage 2, I'm not convinced that this amendment is necessary, given that section 12 of the bill already includes reference to consideration of the child's relationships with other people. Now, given these points, it appears that this amendment is at best unnecessary and at worst risks creating what Children First and Scottish Women's Aid have described as an inappropriate hierarchy of views that any given child might like to express. So I therefore encourage the member to withdraw, but if not, we shall vote against Amendment 35, but for the others in this group.
Thank you. James Kelly to be followed by Fulton McGregor.
Thank you, Presiding Officer. Scottish Labour will be supporting all amendments in this group. In terms of the government amendments brought by Ash Denham, these building amendments I brought forward at stage 2 in order to give voice to the child's views in a court hearing. The bill as originally drafted was a bit loose, and the effect of the stage 2 amendments and the stage 3 amendments give more consistency, ensure that a child's view can be heard, and also gives weight to the mechanism for the child being able to express that view. So I think that improves the bill overall. In terms of Alec Cole-Hamilton's amendment, throughout the process, some campaigners have sought to argue for presumptions in favour of grandparents and shared parenting. This is not an approach I've supported throughout. However, I recognise, in terms of the argument that Alec Cole-Hamilton makes, that this amendment is about the views of the child and the views of the child in terms of which family members they wish to maintain contact with. In relation to Liam MacArthur's amendment, we're also supportive of that, believing that a review is essential in terms of children's participation, and I think 5 years is a reasonable timescale.
Thank you very much. Fulton McGregor to be followed by John Finney.
Thank you, Presiding Officer. I just want to rise to simply support the government amendments and that from Liam MacArthur. I think that as a member of the committee, it's clear that from the get-go the purpose of the bill was to put the interests and the views of the child at the centre. I think that the Minister has clearly listened to some concerns that were raised at committee, and most of these amendments tighten that up and hopefully make it a better legislation. I think that Alex Cole-Hamilton's amendment is well placed. We heard evidence from that during committee, but I think that the Minister's amendments actually supersede that and probably take away any concerns that it maybe have there. So I would respectfully ask him not to press that amendment.
John Finney.
Presiding Officer, I join with others in supporting all amendments of the group. I unfortunately accept Mr Cole-Hamilton's for many of the reasons that's been outlined there. I recognise the refinement that's taken place between the stages there, but I do align myself with the Scottish Women's Aid and Children First briefing that's been alluded to, and the danger of an inappropriate hierarchy, not least because, as the briefing tells us, many children have important relationships with other people outside the family, and the amendment does not define family member. So it's important that all the views of child are taken on board, and for that reason we won't be supporting that amendment. Thank you.
Thank you, Mr Finney. And I call on the Minister Ashdenham to wind up in this group.
Thank you, Presiding Officer. So the bill already makes provision for seeking the views of the child in a range of contexts, and it requires the court to take account of the child's important relationships with other people other than parents, and that has been designed specifically so that it does include people like grandparents. The member and I have, on Amendment 35, have had discussion about this in the past at length, and I've no doubt the member is well intentioned on this issue with Amendment 35. However, I do not think that the amendment does what the member thinks that it does. Therefore, I would not recommend supporting it, and I note that mostly across the chamber that seems to be the consensus that has emerged through this debate.
Thank you. So the first question is that Amendment 8 in the name of the Minister be agreed to. Are we all agreed? Yes. We are agreed. I'm just going to make sure that members online also agree. Just give members a chance on blue jeans to press their button. It's not quite as quick as it is in the chamber. No negation. That is agreed. Can I call Amendment 35 in the name of Alex Cole-Hamilton? Alex Cole-Hamilton to move or not move? That is not moved. So we're going to turn now to Group 2, matters to be considered in making an order under Section 11(1) of the Children's Scotland Act 1995. I call Amendment 9 in the name of Rhoda Grant, grouped with Amendments 10, 11 and 26. Rhoda Grant to move Amendment 9 and speak to all amendments in this group.
Thank you, Presiding Officer. Amendment 9 is a technical amendment. It removes a definition that is no longer required in the bill. Amendment 10 amends 11ZA 3E. Instead of reading the effect of the fact that 2 or more persons would be required to cooperate with one another with regard to matters affecting the child, it would then read whether it is or would be appropriate for an order to require that 2 or more persons cooperate with one another with regards to matters affecting the child. These amendments relate to the Bill's protections in the new Section 11ZA, ensuring that when making an order under Section 11(1), in the context of domestic abuse, the court must have regard to the impact of an order an order would make on 2 or more persons that would be required to cooperate. My reasoning for promoting these amendments is that domestic abuse can continue to be perpetrated through the use of contact. The court must consider this before asking a survivor to cooperate with an abuser. Amendment 11 removes the definition of person in Section 11ZA5 for the purposes of Section 11ZA3E. The effect of removing the definition is to require the court to consider whether it's appropriate to require any persons to cooperate with one another as part of an order under Section 11 of the 1995 Act, rather than consider only cooperation between the types of person mentioned in the definition. And this reflects that parties to the case who are required by an order to cooperate may not necessarily be the parents. Removal of the definition of person in this context, Amendment 11, ensures wider judicial scrutiny on the order's impact beyond actions involving only those who are parents of the child in question or who have parental rights and responsibilities. We know from those using our specialist domestic abuse services that contact arrangements with family members, such as grandparents, can often be exploited by perpetrators of domestic abuse to further their abuse. Therefore, placing a duty on the courts to consider the appropriateness of cooperation beyond parents in order to ensure children and non-abusing parents are kept safe increases the protection afforded to survivors of domestic abuse. I move Amendment 9.
Thank you very much. And I call on Liam MacArthur to speak to Amendment 26 and the other amendments in this group.
Thank you, Presiding Officer. Amendment 26 seeks to make equally shared parenting the starting basis for custody orders, but does not prevent courts from then deciding on the most appropriate split based on the circumstances of each case and, crucially, the best interests of the child. The intention of this amendment, which mirrors one I lodged at stage 2, is certainly not to make shared parenting mandatory. Rather, it would require the court to start with that option when one of the parents requests it, before going on to consider any reasons why a different pattern is better for the child or children in question. I remain very firmly of the view that this legislation should do nothing that might dilute the primacy of the best interest of the child in any decisions that are taken around residency, access or other considerations. Yet, I do not see how requiring the courts to work from the presumption set out in this amendment would do that, as the court would still be free to reject that option either immediately or in due course, depending on circumstances and facts relevant to the case. Moreover, the presumption of shared parenting is one that already exists in other countries which equally share our determination to prioritise the child's best interests. My amendment reflects the general benefits for children of shared parenting that we see in international research, be that in terms of their social and psychological well-being, educational attainment or avoidance of adverse experiences. Of course, such shared arrangements may not be practical or desirable, but given how rarely courts appear to rule in favour of an equal split in parenting responsibilities, it seems reasonable to ask whether or not there is already a presumption inherent within the system. I'll take an amendment from John Finney.
John Finney.
Thank you, President Officer. I'm grateful for the member giving way. The member will be aware of the position that was adopted in relation to other matters that was unhelpful to have a list. Is this not just part of a list? Is it not if we have exclusively the child's interest? There's no need to say this. It may or may not apply, depending what's in the best interest of the child.
Liam MacArthur.
I think John Finney is right to point to both the evidence that we took and some of the considerations we weighed up during the course of stage 1 and stage 2. I think in relation to this amendment, and as I was saying, that given how rarely courts appear to rule in favour of equal split of parenting responsibility, it does seem reasonable to ask the question as to whether or not there are already presumptions that have a bearing within the system. And if so, we should acknowledge that and also satisfy ourselves that it is any less detrimental to the principle of a child's best interest than starting from a presumption of shared parenting. We have all, I'm sure, been contacted over recent weeks by constituents and others wishing to share with us the details of the fallout from their own relationship breakdowns. None of it is pleasant. Often it can be heartbreaking, but nor is it something where we can safely take a definitive view. We cannot be sure we have all of the facts. That is why it must be left to the courts, supported by expert advice and with access to all of the facts, to make a determination in the best interest of the child. However, why should those facts not be applied after starting from a presumption of shared parenting? Presiding Officer, society quite rightly expects relationships to be based on a more joint and shared parenting model than may have been the case in the past. This recognised not least the benefits to the child or children that comes from such an approach. Why then should it not be that we work from a similar starting point in the event of that relationship then breaking down? Amendment 26 would allow for this to happen. Thank you.
Thank you very much. I call on Liam Kerr to be followed by James Kelly.
Thank you, Presiding Officer. I'm happy to vote for all the amendments in this group with the exception of Amendment 26 by Liam MacArthur. Again, I understand the motivation behind this. Of course we do, and the scenarios set out by Mr MacArthur. However, the key consideration here is the welfare of the child. And that means that in decisions regarding parental responsibilities, the only criterion should be what is in the best interest of that particular child. Now, I know Mr MacArthur gets that from his comments that I listened to very carefully. But that is the thread that weaves through this bill. And the committee heard representatives of Yellow who said adults always seem to be given more priority than children, even though it is all supposed to be about the child. We hope that this bill will change that. And I worry that this amendment will move from that basic premise. And finally, I also note Children First and Scottish Women's Aid submissions because they're strongly opposed to this amendment. And for those reasons, I shall vote against the amendment.
Thank you very much. I call James Kelly to be followed by Rona Mackay.
Thank you, Presiding Officer. I want to support Rhoda Grant's amendments. They are sensible and bring more consistency to the bill that concluded at stage 2. Like others, I want to oppose Liam MacArthur's amendment, Amendment 26. I understand the reasoning in bringing it forward. However, the issue to me is that given regard to a shared parenting order, that potentially would override the views and what's best for the child. So we won't be supporting Liam MacArthur's amendment.
Thank you. Rona Mackay to be followed by John Mason.
Thank you, Presiding Officer. I'm not supporting Amendment 26 because I believe it could have adverse consequences in relation to child safety. In an ideal world, it's preferable for a child to have a happy relationship with both parents where possible. But we don't live in an ideal world, and putting this in the face of the bill would be unwise and possibly dangerous for a number of children. All research in the matter suggests that a presumption of shared parenting in any high conflict case is likely to be harmful to the child. A large number of contact cases that end up in court concern reports of domestic abuse, and even those that don't are still likely to be cases of high conflict by the very fact that court's involved. The amendment proposes residence on an equal basis as the default solution in every case unless otherwise agreed. I believe this cuts across the rights of the child and do not believe it would be in their best interests. We heard powerful evidence during committee from children on their experience of imposed contact, and it was harrowing and distressing. This amendment would mean that on request from any parent, even one who may not be a party to a case, the court must consider ordering residence on an equal basis. So, of course, parents should have a equal part in a child's life, but you can't prescribe a one-size-fits-all approach, which is the effect this amendment would have. Every circumstance is different, and child protection is far too important to take risks with. Thank you.
And I call John Mason.
Thank you very much. I really wanted to express my sympathy for Liam MacArthur's amendment. Over the years, I've had many constituents, and in fact others from out with my constituency, one who actually worked at the time in the Scottish Parliament. Mainly fathers, but occasionally mothers, who sat down with me and told me their story as to how the courts had decided, the children had decided that they should have contact with both parents, but it didn't actually happen. And it does seem to me that there's been an imbalance in the court system. I have not been heavily involved in this bill, but something has to change. And I would just look to the Minister to give us a reassurance that we are moving forward in this, that we will continue to move forward after this bill is passed, and that we will see more cases where both parents have real input in the lives of the children. Thank you.
Thank you. And I call on the Minister, Ashton.
So I support Amendments 9, 10 and 11, and I'm grateful to Rhoda Grant for the constructive engagement that we have had on this subject. Those amendments make technical changes to the provisions inserted by Rhoda Grant at stage 2. Where the court is considering making an order which requires 2 or more persons to cooperate, the amendment will require the court to consider whether it is or would be appropriate to require cooperation. This is wider than 11(7)(d) and 7(e) of the 95 Act, and also section 11ZA3, which was added at stage 2 of the bill. And this meets one of the aims of the bill, which is, of course, to further protect victims of domestic abuse, including children. Turning to Amendment 26, in the name of Liam MacArthur, I can reassure members that my view is that both parents should be fully involved in a child's upbringing as long as that is in the best interest of the child concerned. Parents can currently ask the court for residence on an equal basis, and a decision will be made where the welfare of the child is paramount. taking into consideration the views of the child, with full consideration given to arguments for and against shared parenting in the particular circumstances of the case. The amendment proposes residence on equal basis where requested as the starting point for the court to work from. And in my view, this cuts across the approach of the 95 Act, which encourages the court to arrive at a solution which best promotes the welfare of each child according to their individual circumstances. And the amendment refers only to parents. While most cases of this nature are between parents, they don't have to be. For example, grandparents may apply for an order, and the amendment doesn't take account of the full range of circumstances that exist in these type of cases. The amendment doesn't address the stage in the proceedings at which any request must be made, whether the parent requires to be a party to the proceedings, whether it might be open to parents to make repeated requests. In the absence of any attempt to govern the procedure by which such requests might be made, there is a considerable risk of delay in court proceedings with issues arising at a late stage. A Section 11 case may be about contact or about administration of a child's property and not about residence, and the consideration of residence may not then be appropriate for the court to consider in every case, as the court may not have the necessary information to allow it to decide on such questions. And the courts already apply a general principle that it will be normally beneficial for children to have an ongoing relationship with both parents. And the bill strengthens this position by requiring the court to consider in every case the effect of an order in the involvement of the child's parents in bringing the child up. So I don't consider this amendment as desirable. I think this amendment cuts across the general principles of Section 11 of the 95 Act, that the welfare of the child is the paramount consideration. And given those reasons that I've laid out, I would ask the member not to press the amendment.
Thank you very much. And I call on Rhoda Grant to wind up in this group and to press or withdraw Amendment 9.
Thank you, Presiding Officer. I'd like to press Amendment 9. I think we've all had casework where contact has been used to perpetrate abuse with disastrous consequence for the abused partner and indeed their children. And even when the child is not abused themselves, their experience of abuse is an adverse childhood experience, and it impacts on their mental health, their self-esteem, and it damages their life chances. Therefore, there should be a presumption against contact of any kind with an abusive partner when we're looking at child contact. So I move Amendment 9 and urge Liam MacArthur to withdraw his amendment.
Thank you very much. So we'll move to the question. The question is that Amendment 9 be agreed to. Are we all agreed? Yes. And we are all agreed. Can I call Amendment 10 in the name of Rhoda Grant? Rhoda Grant to move.
Moved.
Thank you. Question is that Amendment 10 be agreed to. Are we all agreed? Yes. We are agreed. Call Amendment 11, Rhoda Grant to move.
Moved.
Thank you. The question is that Amendment 11 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 12, Minister Ashton to move?
Moved.
Thank you. The question is that Amendment 12 be agreed to. Are we all agreed? Yes. We are agreed. Call Amendment 13, Minister to move.
Moved.
Thank you. The question is that Amendment 13 be agreed to. Are we all agreed? Yes. We are agreed. And we're going to turn now to Group 3. This is on the disclosure of information. Can I call Amendment 36 in the name of Liam MacArthur, grouped with Amendment 46? Liam MacArthur to move amendment and speak to the other amendment in the group.
Thank you very much, Presiding Officer. Amendments 36 and the more substantive 46 respond to concerns raised with the committee at stage 1 that at present intimate and highly sensitive information shared by a child with a third sector organisation can be drawn into court proceedings. This appears to happen even when sharing such information goes against the interests of the child in question, and often without the child even knowing. It's not hard to see how this could fundamentally undermine the trust and confidence of children who engage with third-party organisations at a time where they are feeling vulnerable. I successfully moved an amendment at stage 2 to address this concern, as indeed did the Minister, and I'm grateful to Ash Denham and her officials for the constructive way in which they've engaged with me since stage 2 in tidying up the provisions here and making further necessary changes. This is a sensitive area, and I recognise the concerns the Government had in relation to my earlier amendment, notably around the use of paramount consideration and even some potential ambiguity over which child was being referred to. I believe Amendment 46 addresses those concerns while still retaining the core principles and protection that I and other committee colleagues sought to have enshrined in this bill. In particular, the inclusion of specific reference to the best interest of the child as a primary consideration in line with UNCRC, and also ensuring that a child has the opportunity to express their views to the court, which then needs to take these into account when decisions are made about sharing their information. In response to those anxious about the potential impact on the rights of others involved in any court process, I would repeat the assurance from Children First and Women's Aid that these changes, quote, will not prevent information from being shared where it is proportionate and relevant to the court. Indeed, our organisations strongly believe that proportionate and relevant information sharing is in the child's best interest to keep them safe and ensure the courts are equipped with all the details at their disposal to make informed decisions. So again, I thank committee colleagues, the Minister, and of course Children's First and Scottish Women's Aid for helping get us to this point. Hopefully, these changes will give children the confidence they need and should have in their conversations with third sector organisations, often at times, as I say, of real vulnerability. And I move Amendment 36.
Thank you very much. And I call on Liam Kerr to be followed by the Minister.
Thank you, Presiding Officer. We will vote against both amendments in this group. Amendment 36 is a function of 46, and so I'll deal with the latter in depth. I vote against Amendment 46 based on a semantic point, which may be much more than that. The language used in the amendment is about considering the child's best interests as opposed to the child's welfare. Now, my understanding of this area of the law is that what is referred to in, for example, the Children's Hearings Act of 2011 and the Adoption Act of 2007, what is commonly understood, what has had cases decided around it, is the welfare of the child. So, hitherto, welfare has been the touchstone. So, why the change of language? Well, I'm grateful to Mr MacArthur for his confirmation it's around the UNCRC, talking about the best interest, to which I shall return. But in any event, we risk importing new terminology without debate, without scrutiny, and without test. Now, maybe I'm making a mere semantic point. There may be no difference between the best interests and the welfare of the child. But if that is right, we should not be introducing new wording. We should stick with the current, because a change at least opens the door to the argument, and that cannot be desirable. But on the other hand, what if it does mean something different? What if best interest and the welfare of a child are different in law and in practice? We need to be very careful to understand what those changes are on a practical level before codifying that in black letter law. So the safest path is to vote against these amendments, and I plead as further authority that Minister Marie Todd confirmed on the 4th of May that the government still intends to introduce the UNCRC bill this year. Now, no doubt there will be consultation around that, and presumably, as part of that, the meaning of best interests. So let's take the precautionary principle and wait till then. I shall vote against Amendment 46.
Thank you very much, Mr Kerr. I call on the Minister Ashton.
Thank you, Presiding Officer. So I support these amendments. I'm grateful to the member for the constructive engagement that we've had on the subject, and I'm pleased that a consensus position has been reached. And I hope members will be able to join me in supporting these amendments today. Two competing amendments were made to the bill at stage 2, and amendments 36 and 46 remedy this issue by removing both sections 1A and 13A from the bill and inserting in their place a new section. These amendments retain elements from and improve on each of the sections that were added to the bill at stage 2, and they provide that when the court has to decide whether a person should have access to anything in which private information relating to the child is recorded, it must regard the best interests of the child as a primary consideration. And the references to best interests and primary consideration, as noted by Mr Kerr, reflect the language of Article 3.1 of the UNCRC and the approach taken in General Comment 15. The use of the words "a primary consideration," as is proposed, achieve a more appropriate balance of rights than Section 1A did. And these amendments also go further than Section 13A did by requiring that the views of the child to be sought using the manner preferred by the child. And I appreciate there may be some cases where this is not going to be possible in the best interest of the child, although again, it would expect the exemptions to be used only infrequently. The amendments offer wider protection than Section 1A of the bill, which appear to only protect the child at the centre of the Section 11 proceedings. And I would like to reassure members that I am already progressing work to ensure that children are informed of how the information that they disclose to a child welfare reporter might be used. And I have shared a draft of the guidance for children on speaking to child welfare reporters with key stakeholders earlier on this summer, and once I have a finalised version, we'll look to publish this and make it available to children and young people. So I hope members will join me in supporting these amendments, which constitute an important protection for the rights of children whose private information may be used in contact and residence proceedings.
Thank you. And I call on Liam MacArthur to wind up and to press or withdraw Amendment 36.
Thank you very much, Presiding Officer. Can I thank the Minister again for her support and her explanation of the basis of that support. Can I thank Liam Kerr for his comments and for engaging the debate around this? I would never accuse him of semantics. To some extent, though, the language being used here is similar to the language that was used in the amendment I lodged at stage 2, and I don't recall those concerns being raised at that stage. I think the Minister has set out the consistency of approach that's been taken here. I think it's difficult to see how a child's best interest would not be observed by any measure that was adhering to the child's welfare. This is embedded within UNCRC. I take the point that a fuller integration of UNCRC into Scots law is proposed, but I don't think that is a justification for kicking the can down the road, where there's an opportunity here to embed this provision. Those that gave evidence to the committee were very clear about the importance of this, not least, as I said earlier, for safeguarding the confidence that children and young people have in the engagement they have with third sector organisations at a time of real vulnerability for them. And on that basis, I will be moving Amendment 36. Thank you.
Thank you very much, Mr MacArthur. So the question is that Amendment 36 be agreed to. Are we all agreed? Yes. We're not agreed. Now, this is the first division of the afternoon, so I'm going to suspend proceedings. We're going to have a short technical break. We're going to allow, this is not just to summon members to the chamber, but also to allow members online to make sure they're on board the system to vote. So a short suspension. And I should say to members on blue jeans that the system will go quiet for a few minutes, then I'll come back with instructions. Okay, colleagues, thank you. We're going to resume proceedings now. We're on Group 3, disclosure of information, and the Amendment 36 has been moved by Liam MacArthur. There was an indication that we're going to divide. So the question is that Amendment 36 be agreed to, and members may cast their votes now. Amendment 36. This is a 30-second division. 30 seconds. Members should refresh their screens if they're logged out. Refresh your screen. The result of the vote on amendment number 36 in the name of Liam MacArthur is yes 86, no 30. There was one abstention. The amendment is therefore agreed. A point of order, yes. Yes. Okay, point of order from Jenny Gilruth. Ms Gilruth, that's right. If Ms Gilruth wishes to indicate to the Chamber which way she voted. Yes, but which way do you... Okay. The vote was overwhelmingly yes, but your vote has been now recorded for the record. Point of order, yes. Claire Hawkey, point of order. Claire Hawkey, just wait a second, Ms Hawkey. I think your microphone might just be... There we are.
Oh, I wasn't able to vote either.
And Ms Hawkey, would you like to indicate which way you were going to vote?
In support.
In favour?
Yes.
Okay, so Ms Hawkey also voted yes. And Stuart McMillan, point of order. No, it's important at this stage. Yes, Mr McMillan.
Point of order,
Mr McMillan. Let's hear Mr McMillan, please.
Same situation for me, Presiding Officer, and I would have voted to support it.
Thank you. That has also been noted for the record. Now, can I just say to colleagues that from now on, we're not going to have a technical break unless there is widespread disapproval that people aren't voting. So it's important that members keep their screens open and refreshed. If it moves away, log back in again and refresh your screen, and it should come back on again. You've got the code. You should be able to vote. It's up to members now to be able to use the system. Now, I'm also going to add for the record that Rachel Hamilton, who's been joining us remotely, was also not able to vote, and she voted no. She voted no. So we're going to move on. I'm going to call Amendment 14 in the name of the Minister. Minister to move formally. This was debated earlier with Amendment 8.
Moved, Presiding Officer.
Thank you very much. So the question is that Amendment 14 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 15, Minister to move?
Moved.
Thank you. The question is that Amendment 15 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 16, Minister to move.
Moved.
That is moved. The question is that Amendment 16 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. We're going to turn now to Group 4, which is on vulnerable witnesses and vulnerable parties. Can I call Amendment 37 in the name of the Minister, grouped with Amendments 38 and 39? Minister to move Amendment 37 and speak to all the amendments in this group.
Amendments 37 to 39 seek to provide further protection to vulnerable parties in evidential and non-evidential hearings, in particular child welfare hearings and vulnerable witnesses when a case under Section 11 of the 95 Act reaches proof. When a person is deemed to be a vulnerable witness by virtue of Section 11B of the Vulnerable Witnesses Scotland Act of 2004, as inserted by Section 4 of the Bill, Amendment 37 requires the court, before the proof or any other hearing at which the witness is to give evidence, either to make an order authorising the use of a special measure, or make an order that the witness is to give evidence without benefit of a special measure. And this will ensure that consideration of special measures does not depend on the party lodging a vulnerable witness application or the court considering the matter of its own volition. A party may be deemed to be a vulnerable witness if there is in force a non-harassment order, interdict or any similar order or remedy granted by a court prohibiting certain conduct towards the person by a party to the proceedings. A relevant offence has been committed against the person and a party to the proceedings has been convicted of committing it, or if a party to the proceedings is being prosecuted for committing a relevant offence against the person. Where a party would meet the criteria to be deemed to be a vulnerable witness if they were to give evidence, Amendment 38 requires the court to either order the use of any special measure the party requests or order the use of a special measure that the court considers appropriate and explain why the preferred method is not used or give reasons for not ordering the use of special measures. Special measures can include screens, giving evidence by live video link and having a support attending with a party. Amendment 39 is a consequential amendment to remove a now superfluous reference in relation to a party from the provisions in relation to vulnerable party. And if these amendments are agreed today, I would propose to work with stakeholders such as Scottish Women's Aid in preparing a policy paper for the Family Law Committee on the Scottish Civil Justice Council on any changes to court rules that may be necessary. And these amendments build on provisions in Section 4 and 5 of the bill in relation to prohibition of personal conduct of a case and vulnerable parties in child welfare hearings. And I hope that members across the chamber will agree with me that it is important to ensure that vulnerable parties and witnesses are protected, and I move Amendment 37.
Thank you very much, Minister. Now, no other colleagues have indicated they wish to contribute to this group, so unless the Minister has anything to add, we're going straight to the vote. Thank you, Minister. So the question is that Amendment 37 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 38? Minister, to move.
Moved.
Thank you. The question is that Amendment 38 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 39. Minister, to move.
Moved.
That is moved. The question is that Amendment 39 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. We're going to turn now to Group 5. This is on child welfare reporters' qualifications and experience. Can I call Amendment 40? In the name of Liam MacArthur, this is grouped with Amendments 1 and 2. Liam MacArthur to move Amendment 40 and speak to all the amendments in this group.
Thank you, Presiding Officer. Amendment 40, which again reflects an amendment I lodged at Stage 2, would ensure that the role of child welfare reporters carried out by appropriate qualified and registered social workers reflecting practice in other parts of the UK. I'm aware of suggestions that this amendment may constitute a conflict of interest due to my wife's role with Relationship Scotland Orkney. I failed to see how this is the case, any more than it might be for those with connections to the legal profession to oppose my amendment, but I'm happy to remind the Chamber of that interest nonetheless. As colleagues will be aware, at present the vast majority, around 90% of child welfare reports are carried out by lawyers. As I acknowledged at Stage 2, there are many lawyers who have built up a wealth of experience in this area. I have no doubt they bring a range of skills and expertise to that task, not least in the gathering of evidence and an understanding of the court process. But assessing a child's welfare is complex and requires different skills. As the Scottish Association of Social Workers highlight, quote, children who are subject to child welfare reports are often the silent victims of their parents' acrimony and inability to reach agreement about their future well-being, safety and security through the rest of their childhood. They go on to say, they will have listened to their parents argue, they will have wanted the arguing to stop, they will often have divided loyalties with both parents whom they love but may be frightened to say so, and they have often learnt that being silent is the way to cope. The skills that are needed in helping children talk and for their views to be heard are complex and take time to develop. particularly understanding the dynamics that happen in families and between adults and children. The association concludes, we are concerned that children involved in this process are currently not getting the support they need to help them understand the court process and decisions, and are assessed by professionals who do not have the qualifications required to do this sensibly, whilst also being aware of complex issues such as domestic abuse, substance misuse, trauma, parenting capacity and parental influence. This is a point reinforced by Andrew Smith, QC, in a briefing circulated ahead of this debate. He said, being a lawyer does not make you good at investigations, especially where children are involved. In fact, I suppose it is arguable that it should disqualify you, as the job of a lawyer is to plead a case from one side or the other and not to be neutral. Andrew Smith adds, the most important thing from everyone's point of view is that any person appointed to carry out a report is properly trained in child reviewing, that their reports are transparent as to why findings are reached and fact-based, that their decisions can be reviewed if necessary by complaint, and that they can be removed from the register of approved reporters for failings. I recognise that such a dramatic change from what is in place at present is difficult to conceive. I understand the reaction of lawyers who may feel that this amendment devalues their skills or questions their motives, and I certainly do neither. And I appreciate the concerns expressed about how, in practice, the new burden on the social work profession might be shouldered without creating delays in the process that could prove so damaging to the welfare of a young child. Yet I think we do need to ask ourselves the question that if we were constructing a system from first principles with the intention of putting the welfare of the child at the centre of the process, can we honestly say we would envisage such a role being taken on by lawyers rather than those with a background in social work? I have little expectation that my amendment will gain the support of the Chamber. I have sought to manage expectations in that regard. However, I do think that the issue demands to be considered by the Parliament as a whole, and on that basis I look forward to hearing the views of other colleagues and indeed the Minister. In the meantime, move Amendment 40 in my name. Thank you.
Thank you very much, Mr MacArthur. I'm now going to call Neil Findlay to speak to Amendment 1 and the other amendments in this group. Mr Findlay.
Thanks, Presiding Officer. And before I start, I will listen very carefully to what the Minister has to say in response to these amendments before deciding whether to press or not. A child welfare reporter can be a stranger to a child. They're often paid to carry out their role and may only have met the child or family once. The reporter, despite their training, may not have any real experience of dealing with children except in this role. A child is unlikely to speak to a complete stranger about a perhaps complex and potentially frightening relationship they may have with one or other parent. There should be a system of welfare reporting that is carried out professionally by those who have worked with children and who fully know the law concerning children's rights. This could be a children's rights officer or another named professional. My constituent who brought the petition to Parliament believes that solicitors should not be the people who perform this role. Amendment 2, it's important that those who have experienced the worst and indeed the best of the system have the opportunity to shape the changes to it. And we have to consider these changes from the perspective of the people who are involved in the system, particularly the children and the parents, their parents. Children are, of course, at the centre of the system of contact. Therefore, changes must be made with their interests at heart. The views of young people can be overlooked, but we cannot allow that to happen with this legislation. Children are very able to express a view on what they like and what they don't like, what upsets them or scares them. And adults who have experienced trauma or domestic abuse at the hands of a partner who is party to a court order contact must also be able to shape this legislation and any regulation that comes forward. All this amendment seeks to do is ensure that this happens and that the system is as user-friendly and child-friendly as possible for all those who use it.
Thank you very much. I've got a number of members who have indicated they wish to contribute. Liam Kerr to be followed by Rona Mackay. Liam Kerr.
Thank you, Presiding Officer. We'll vote against all amendments in this group. Dealing briefly with Amendment 1 and 2, we understand there's a full consultation on child welfare reporters planned and imminent. I've no doubt the Minister will speak to that, but the most recent reference I can find is a letter of 21st of May 2020 from the Minister at which these matters are dealt with over several pages. The substantive discussion I wish to make is around Amendment 4. 40. So only a social worker may be appointed as a child welfare reporter. This has attracted many representations, which I've taken time to consider. I understand the points we made, and I listened carefully to Mr MacArthur's representations. I'm persuaded to vote against it for several reasons. I'm concerned about the resourcing implications and the capacity of local authorities, what impact this might have on the timescales and the progression and the impact of the work that the social workers are doing besides. I am led to believe that frequently sheriffs request reports to be completed within a very short time scale, which I worry could be difficult for social workers with a heavy workload. On which point, we've had representations that around 90% of child welfare reporters are lawyers. It would be very difficult to lose that pool of expertise by limiting the role to social workers. I also see the Law Society's concerns that a sheriff already has the power to call for a social work report in a child welfare case, so they argue that this clause could reduce a sheriff's options. My feeling would be that it is consistent with the welfare of the child ethos to ensure a sheriff has the most options available to suit individual circumstances. And finally, I understand the consultation about this bill didn't make reference to restricting qualification to social workers only, rather it intended to regulate the solicitors and others already registered who undertake these duties nationally to standardise the qualification. Without hearing representation, they'll be very reluctant to legislate in this area. I think perhaps even more persuasively, the fact that Social Work Scotland submitted a considered submission yesterday saying we oppose the amendment, I find particularly persuasive. Not least their point, no detailed analysis has been done to ascertain whether this amendment would be viable. On that basis, we'll vote against.
Thank you. I call Rona Mackay to be followed by James Kelly. Rona Mackay.
Thank you, Presiding Officer. I rise to speak against Amendment 40 because I think it's far too prescriptive and frankly unrealistic for all child welfare reporters to be social workers. It's true that currently 90% of welfare reporters are lawyers, and that does need to be addressed. But to agree to this amendment would shift the balance entirely in the other direction and would be out of proportion with what's required and achievable. Government believes in getting the right balance of lawyers and non-lawyers through child-focused training for all undertaking this role. Regardless of their professional background, the key aim is for reporters to have the necessary skills and experience. I know of many family court lawyers who have a wonderful understanding of working with children, and they're incredibly skilled, and we don't want to lose that. Some social workers may not have all the necessary qualifications and experience in engaging with young people. In addition, there is the question of capacity within the resources of social work and the pressure this would cause on an already overworked profession. This amendment is not supported by Social Work Scotland, the Family Law Association, Scottish Women's Aid, Children's First, the Children and Young People's Commissioner, Shared Parenting Scotland and the Scottish Courts and Tribunal Service. So in conclusion, I support a system of enhanced training for engaging with children from across a wide variety of professional backgrounds, which is what the Government proposes to do.
Thank you very much. I call on James Kelly to be followed by John Finney.
Thank you, Presiding Officer. I want to speak against Amendment 40 in Liam MacArthur's name and support Amendments 1, 2 in Neil Finley's name. I think the starting position in this debate, considering the role of child welfare reporters, is to ensure that there is an adequate pool of suitably qualified individuals in order to best service the needs of the child. I think regrettably the amendment brought forward by Liam MacArthur would limit that pool and would reduce the pool of people available. There would be significant resource implications if this were to be passed. I give particular weight to the submission we received yesterday from Social Work Scotland opposing the amendment brought forward by Liam MacArthur. And I don't think it is helpful in that regard. I think the approach adopted by Neil Finley is a more prudent one in the sense that it acknowledges the role of opening it up to suitable individuals and, as Neil Finley said in his speech, those with lived experience. So I think there is an issue here in getting the right people there ready to serve the child. However, restricting it only to social workers would have an adverse effect. So Scottish Labour will oppose Amendment 40 and support Amendments 1 and 2.
Thank you. And I call John Finney to be followed by Fulton McGregor.
Thank you very much, Presiding Officer. Likewise, we will not be supporting amendment number 40. I think it's been a very useful debate. It would be wrong to characterise that debate as social workers versus lawyers. I've met with representatives of both groups, and of course the Justice Committee had the pleasure of hearing from Yellow, the group of young survivors who reported, and this is going to be repeated, I'm sure, again and again, that their words were not only misunderstood but led to them being misrepresented. So registration in itself, I don't think is sufficient. I declare an interest of family members who are or have been social workers. There's undoubtedly they'll have the qualifications. Some of them may, as others have said, not have the experience. I can't imagine that someone who spent an entire career, for instance, dealing with adults in criminal justice would necessarily, I'm not saying that they wouldn't, have that level of engagement. To me, it's about listening. So and understanding child development. And on development, the development of regulations around this is the time for all of these people to have their input, so that with the proper people in place, whoever they may be. We won't be supporting amendment number 1, but we will be supporting Mr Finley's amendment number 2, because I think it's very pertinent to have regard to issues like domestic abuse and court-ordered contact, not least because of the pernicious impact that coercive control and behaviour can have in however talented someone is in getting the correct information from a child. Thank you.
Thank you very much. Now call on Fulton McGregor to be followed by the Minister.
Thanks very much, Presiding Officer. I've got quite a lot of sympathy with Liam MacArthur's amendment 40, but I do think that this bill is taking us in the right direction. What we should be doing, and it came up in committee quite a lot, is making sure there's more social workers doing reports rather than it should all be social workers. And I think that point has been made. Presiding Officer should probably point members to my register of interest as well. I think that the amendment does have the right idea behind it, but there's quite a lot of unanswered questions, like what sort of social workers would it be? Would it be every social worker? Or, I think as Rona McQuaid pointed to, would it be more likely to be child protection social workers? What pressure would that put on social work resources? I think it is telling that Social Work Scotland have come out and said that they don't agree with this amendment. I think that what we need to do is look at turning the tide a wee bit to have more social workers involved in doing these welfare reports, and not solely social workers. Because some lawyers are very good at it as well and have spent their careers dedicated to this and training in this area. So I can't unfortunately support this amendment, but I would like to thank Liam MacArthur for giving it the airing that it has, both at stage 2 and here, and putting social work in such a front foot in this bill. So I do have a lot of sympathy with it. In relation to Neil Finley's amendments 1 and 2, again, a lot of sympathy with them. They're very much a common sense approach. I think they're things that should be done, but my own view is these should be done in practice. For example, a child welfare reporter, if they don't know the child, they should at least be doing an introductory visit, possibly 2 at the very least. But these are practice issues for social work departments, in legal departments and others, and therefore I don't think they're required in the face of the bill.
Thank you. And I call on the Minister, Ashton.
Thank you, Presiding Officer. The Scottish Government does not support many of the amendments in this group, so Amendment 40 in the name of Liam MacArthur would only allow social workers registered with the Scottish Social Services Council to be child welfare reporters. And my officials have spoken to a number of key organisations who have expressed concern about this amendment. At the moment, around 90% of child welfare reporters are lawyers, and I remain unconvinced that there is a justification for limiting this role to only social workers. In my view, the most important factor for any child welfare reporter is that they meet the required standards in training and in qualifications, regardless of their professional background. This amendment would also exclude child psychologists, child psychiatrists or other family support workers who may have the necessary qualifications and experience to be a child welfare reporter unless they are also social workers. It would also exclude retired social workers who again may have the required skills to act as a child welfare reporter. And it's also not clear whether there is capacity within the social work sector to take this role on. Capacity issues could lead to delays in producing child welfare reports, which could in turn delay the case overall, and that would not be in the best interest of the child concerned. I am, however, very keen to encourage more non-lawyers to become child welfare reporters. I think that diversity of experience in the role of a child welfare reporter would be very beneficial to the process. And I give the member my assurance that these considerations will be taken into account as the regulations on child welfare reporters are developed. As regards to Amendment 1 in the name of Neil Finlay, an identical amendment to this was not supported by the Justice Committee at Stage 2, and it still remains unclear to me what the amendment is intended to do. If a person has the requisite skills and experience to be included on the register of child welfare reporters, then they can be included on that register. And I'm not clear how the person's professional knowledge of a particular child can be relevant to the question of whether a person could be registered as a child welfare reporter generally. I take the member's point that a professional who has already worked with a child may be very well placed to write a child welfare report in relation to that child, although I think it shouldn't be overlooked that there might also be cases in which the child or other members of the family might have a strong preference that somebody new is brought in to do that. So the issue that the legislation is dealing with is not who will write a report in relation to a specific child, it's who can be registered to be a child welfare reporter. And it would obviously be unworkable to have a system under which, in effect, there would be a separate register of child welfare reporters for every child in relation to whom a child welfare report might ever need to be produced. So for the reasons outlined, I remain unable to support that amendment, and I would urge members to reject it. However, on Amendment 2, I do see the point that Neil Finlay is making, and when consulting on draft regulations, any government will of course need to ensure that people with lived experience of court-ordered contacts and domestic abuse give us their valuable insights, and so I can support that amendment.
Thank you very much, Minister. So, Liam MacArthur to wind up and to press or withdraw Amendment 40.
Thank you, President Officer. Can I thank all colleagues for their contributions to the debate. Liam Kerr indicated that this was an amendment that attracted many representations, which I think was delicately put. Clearly, one of the primary concerns was around the resourcing and the capacity, although I think it's fair to say that, as I said at Stage 2, that this would not be confined to social workers within council social work departments, and evidence from elsewhere in the UK suggests that the delays that have been referred to were not necessarily borne out. In terms of the consultation on the proposal originally, I think the questions have been raised about the extent of the engagement from those within the social work sector at the earliest stages in the development of this bill. To Rona Mackay and James Kelly, we both again drew on the points in relation to capacity. I think they made the important point about however this lands, we need to be extending the pool of suitably qualified professionals that are available to the court to carry out these reports. I think it was a point Fulton McGregor made as well, that that needs to include a greater level of social work engagement. Joan Finney, I particularly thank for reminding the Chamber that this isn't about pitting social workers against lawyers. They bring with them different skill sets and they are tremendously valued. Although I would have to note that given the position taken by Social Work Scotland and the position taken by the Scottish Association of Social Work, it appears to be more a case of there being a disagreement between those two elements of the same sector. I can see John Finney looking to rise, so I'll take an intervention from
John Finney.
Thank you. I'm grateful to Mr MacArthur taking an intervention. I absolutely commend the social work representatives for coming forward. That's what a workplace representative body should do, and perhaps it's disappointing that that's the report we got from Social Work Scotland. I wonder if the member would reflect that as we hope to move to a barnhouse model, then a wider range, including police officers, for instance, are the type of people who could be involved in this sort of issue.
That's an entirely fair point that John Finney makes. I mean, I think there's a tendency for us to focus in on the piece of legislation that's in front of us, but I think he's absolutely right in terms of the move towards Barnhouse, that if we are to do it properly, will absolutely need to draw upon a wider range of suitably qualified and trained professionals. But on the basis of the debate that we've had, I think it's been valuable that we've aired this and debated it within the Chamber, not simply within the committee, but on the basis of the responses I've received, we will not be moving Amendment 40. Thank you.
Did the member say he's not moving Amendment 40? Not. So the member is not moving. In fact, actually, sorry, the member will probably seek permission to withdraw Amendment 40 because it was moved earlier. Does any member object if Liam MacArthur seeks to withdraw Amendment 40? No one objects. Thank you. Can I call Amendment 1 in the name of Neil Findlay? This was already debated. With Amendment 40. That is moved. The question is that Amendment 1 be agreed to. Are we all agreed? No. We're not agreed. So we're going to move to a division. Now, I'm not going to suspend. This will be a 1-minute division. If members have any difficulty in voting, please put their hand up. Just try to refresh your screen or log back in again. It should be as simple as that. There's plenty of time to do so in a minute. And similarly, online, if any members have any difficulty voting, indicate online. So members can use their votes now on Amendment 1. Just put your hand up. If members can't vote, wait, give it a chance. If members can't vote, put your hand up, please. Okay, members, I'm just going to temporarily suspend. So the meeting is temporarily suspended. And members online, just make sure you know that. Okay, colleagues, if we resume our seats, we're going to resume business. Apologies for the short suspension. We think we've resolved the technical difficulty there. We're just waiting for broadcasting to start. And members to join us online. So we are resuming proceedings. We are in the middle of a division on Neil Findlay's amendment. So the question is that Amendment 1, in the name of Neil Findlay, be agreed to. And members may cast their votes now. This will be a 1-minute division on Amendment 1. Thank you, colleagues. The result of the vote on Amendment number 1 in the name of Neil Findlay is yes 23, no 98. There were no abstentions. The amendment is therefore not agreed. Can I call Amendment 2 in the name of Neil Findlay? Neil Findlay to move. Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division. This will be a 30-second division. A 30-second division on Amendment 2 in the name of Neil Findlay. Members may vote now. Thank you. The result of the vote on Amendment number 2 in the name of Neil Findlay is yes 91, no 29. There were no abstentions. The amendment is therefore agreed. We're going to turn now to Group 6, which is on the regulation of contact services. I'll call Amendment 3 in the name of Neil Findlay. This is grouped with the amendments as shown in the groupings. Neil Findlay to move Amendment 3 and speak to all the amendments in this group.
Thanks, Presiding Officer. I'll try and not get carried away with the excitement of winning a vote there. On these amendments refer to the regulation of contact centres. No parent should ever have to leave a child at a centre while fearing for their well-being and where staff do not take responsibility for them, but where the parent who is having contact is deemed responsible. Many of the children are there because there is a genuine fear of harm for the child or the resident parent, and yet the resident parent is asked to sign a form to say that they will leave the child, and if they do not, they will be reported to the court, and the court may find them in contempt. This is what happened with my constituent. That has to stop. Who in such a scenario calms the fearful child if the resident parent is not there? A stranger to the child, or the parent the child may well be frightened of? This could be very upsetting and damaging to the child long term. The contact centre must be responsible for the health, safety, welfare and well-being of the child when on their premises. Buildings must be up to an acceptable safety standard. They must have CCTV in rooms. There should be panic rooms, panic alarms. Indoor and outdoor play areas have to be safe. There should be easy access and exit and much, much more, all part of the centre's responsibilities. And the staff who have contact or a role in supervising children must be trained and hold recognised qualifications in relation to the matters relating to children, their welfare, the children's welfare and well-being. This does not mean that a plumber attending the centre to unblock the toilet has to have a qualification in child welfare, but the person supervising or overseeing contact does. Amendment 7, in my view, we need to ensure that the system of contact centres is one that is well run, that carries the confidence of children, parents and the public. The state, through the court's orders, contact via court orders, and that contact, we all accept, must take place in a safe environment for children and those impacted by the court order. The interests of children must be at the centre, and financial considerations, though important, must be a secondary consideration. I believe it's in everyone's interest that such a system should be publicly run and publicly accountable. We have one chance to make this work, and we should ensure that it is run as a public service with an ethos and management reflecting that. We are reforming the system of contact centres, which is already a tendered system, and because of the failings within it, that's why we are reforming it. Yet we want to repeat that failure by putting the service out to tender again. I think that is a wrong move. So I think a publicly run and accountable service has to be the way that this goes forward. It's such a vital area of children's welfare, and it's not just about funding, it's about the whole ethos underpinning the system. We're only at this stage, as I said, because of the failings of the existing system, and this amendment, I think, would put contact centres on a robust foundation for the future. I hope that all the amendments that in the group will be all the amendments I put forward in this group will be supported.
Thank you, Mr Finlay. Can I call the Minister Ashton to speak to Amendment 17 and the other amendments in this group?
Thank you, Presiding Officer. Amendments 3 and 4 in the name of Neil Finlay are in the same terms as amendments that he brought forward at stage 2, and I still cannot support them because I remain unclear what responsibilities they're trying to impose on contact centres. So, as I stated at stage 2, as a Parliament, we simply cannot make people or organisations subject to vague and unspecified legal duties. It would be bad lawmaking, and so if Mr Finlay presses these amendments today, and I hope he won't, I would urge members not to support them. Amendment 5, which is also in the name of Neil Finlay, would require contact centre regulations to include provision for staff to be trained and to hold recognised professional qualifications in relation to issues concerning children. So I agree that staff working in contact centres should have the right professional qualifications, including in recognising behaviours related to domestic abuse and coercive control and associated behaviours in children. I agree with the member there, and we have discussed this in advance of stage 3. However, the bill already provides for training and qualifications for contact centre staff to be set down in regulations, which is what this amendment calls for too. And as those regulations are developed, I'd be very happy to discuss these matters again with Neil Finlay. But I can't support this amendment because it is unnecessary. And as I've said, the bill already provides that the regulations are set out in qualifications for contact centre staff, so it doesn't add anything. I will.
Neil Finlay.
Defer to offer having discussions with me about future regulations. Given that I'm not standing at the election and the Minister has said that it will take 3 years for this system to be brought in, I might not be around for that.
Minister Ashton.
I can hear the Chamber is entirely sad that Neil Finlay will not be around in the next session. However, it is a genuine offer to the member. We have already spoken about amendments that the member brought forward at stage 2. I have tried to support the member where I can, and so I have accepted one of his amendments today. But on these ones, I cannot support them. I feel the approach that I've taken, which is to consult on the regulations, to consult on the training, to consult on the standards of accommodation, all of which will be a new duty. You know, obviously contact centres up until this point were not regulated. This is a huge step forward. So the offer is there that in the next few months, while Mr Finlay is still in the Scottish Parliament, to come and to discuss this with me, and I'm happy to do that. So Amendments 17, 18 and 19 in my name make minor adjustments for readability to wording about contact centre risk assessments, which was added at stage 2 by an amendment from Neil Finlay. And Amendment 41 in the name of Bob Doris seeks to encourage contact centres to comply with their duties under the Equality Act of 2010. And this is in particular in relation to duties to make reasonable adjustments to premises for disabled people. So I fully recognise the seriousness of this issue and the concerns that Bob Doris has voiced on that. And I want to ensure that children who need to go to a contact centre can access that contact centre and that all contact is facilitated safely. And so I'm happy to support that amendment. Amendment 6 is similar to, but not the same as, Amendment 2, which we have already debated, and it calls for consultation with people with lived experience of court-ordered contact and domestic abuse. And as I said on Amendment 2, I totally agree with Neil Finlay that we need to ensure that people with relevant lived experience give us their views when we consult. And so I could support that amendment, but I can't support Amendment 6. And the reason for that is that it's drafted quite differently from Amendment 2. It requires ministers to consult before implementing or reviewing regulations, and it's unclear what that would mean for us in practice. A duty to consult as part of carrying out statutory review of legislation is not unknown, but the requirement here is not linked to a statutory review, so it's ambiguous. And when ministers are treated as reviewing regulations, the concept of implementing is even more vague. So implementation, obviously that's an ongoing process. So when does the duty to consult about it start and when would the duty stop? It would be unclear when ministers are complying or indeed when they're not complying with this legal requirement. I was content to support Amendment 2 as it was clear about what consultation was required and when. And unfortunately, Amendment 6 isn't, so I can't support it. Amendment 42 makes a minor adjustment to the power in Section 9 of the bill, which is technical in nature. Amendment 7, in the name of Neil Finlay, would require regulated contact centres to be publicly provided and accountable to Scottish ministers. So, again, this came up at stage 2, and I said at stage 2, I'm unclear about exactly what this is supposed to cover. So I am aware of concerns that contact centres should be publicly funded in the longer term. And I would point to the amendment agreed at stage 2, which allows Scottish ministers to enter into arrangements for the provision of contact services, which will ensure that they are sustainably funded and subject to government oversight and monitoring. And in addition to the oversight and monitoring provided for by the bill's system of regulation of contact centre providers. So the bill already provides for public funding of contact centres. Whether public funding is what the reference in Mr Finlay's amendment to centres being public provided is supposed to mean, I don't know. I assume that it is. But I have a problem with that amendment as well, so I can't support it because I don't understand exactly the effect that it would have in practice. Amendment 20 places a duty on solicitors to refer their clients to a regulated contact centre. Now, James Kelly lodged an amendment on this at stage 2, which required that all referrals to a contact centre must be to a regulated centre. And I agree with the intention behind Mr Kelly's amendments. But I had concerns around how a duty of this nature could be enforced in relation to individual parents who self-refer. However, I agreed to consider Mr Kelly's amendment further in advance of stage 3. And so Amendment 20 will ensure that all court and solicitor referrals to contact centres are to regulated centres. And failure by a solicitor to comply with this duty may be treated as professional misconduct or unsatisfactory professional conduct and dealt with through the normal professional regulation processes on that basis. I will.
John Finney.
Thank you, President Officer. I'm grateful for the Minister taking intervention. It is our intention to support that particular amendment, but I wonder if it was unwitting offence that's been caused to the legal profession by the insertion of that. There already is provision whereby there's guidance given as to how the legal profession conduct themselves. I wonder if you would reflect if that was perhaps a bit heavy-handed.
Minister.
Well, I did actually consult, or my officials and I have consulted with the Law Society in developing this amendment. And the reason it has been drafted as it has is because I'm very unwilling to put into law something that whether I cannot enforce. So that is why there is the duty is drafted as it is. So I think I have finished on that point now, Presiding Officer.
Thank you very much, Minister. I call on Bob Doris to speak to Amendment 41 and the other amendments in this group.
Thank you, Presiding Officer. In speaking to Amendment 41, I want to thank the Minister for her constructive approach. I raised concerns at both Stage 1 and Stage 2 about disability access to child contact centres. A constituent of mine has faced a 2-year ordeal to secure a contact centre with an appropriate toilet facility with a hoist to enable him to see his child who has cerebral palsy. I thank my office staff for their persistence in pursuing this matter with the contact centre. The contact centre, I understand, is now fully adapted. However, it should never have taken so long. Other contact centres were similarly unsuitable. That's why I sought to specify the minimum standards of accommodation with regards to disability access on the face of the bill with an amendment at stage 2. The government position was that such detail was best left to regulation, which would be consulted upon. The Minister also believed that stage 2 amendment would duplicate existing duties and enforcement mechanisms. Presiding officer, to be blunt, those existing duties did not deliver for my constituent anyway, and duplicating such a duty that is not currently working may not have delivered change. This amendment at stage 3 will therefore take a different approach. The regulator, once appointed, will have the explicit power to issue reports on any failure or possible failure by a contact service provider to comply with the provider's duties under the Qualities Act 2010, and in particular any duty to make reasonable adjustments to premises in order to facilitate their use by a disabled person. I hope this will move beyond the existing legal duties which unregulated contact centres currently do not adhere to, and in the absence of enforceable minimum standards, in the absence of an inspection regime or a complaints mechanism. However, this bill will deliver these elements. With this amendment, we will also have a clear focus on disability access and will provide a mechanism to report on contact centres who do not make reasonable adjustments. In finishing, Presiding Officer, my thanks again to the Minister for agreeing a workable solution and to my constituent who, by sharing their experience, will hopefully secure improved access to child contact centres for those with disabilities for years to come.
Thank you, Mr Doris. And I call on Liam Kerr to be followed by James Kelly.
Thank you, Presiding Officer. Very briefly, we won't support Amendments 3 to 7 in the name of Neil Findlay, but rather than take time up, is for the reasons set out by the Minister. Where I do want to focus my comments is on the Amendment 20. This is a good amendment. We will support it, and there is no problem with solicitors being required to refer to regulated services. That is supportable, no problem. Where I raise an issue for the Minister to think about is that which John Finney quite rightly raised in his intervention. The concern comes in subsection 2, relating to the professional misconduct. The issue here is the background law, the Solicitors Scotland Act at section 34, which provides that if any solicitor fails to comply with any rule made under section 34, that failure may be treated as professional misconduct or unsatisfactory professional conduct. The practice rules for solicitors at B 1.4.1 are clear that a solicitor's fundamental duty to act in the best interest of clients is subordinate to the solicitor's duty to comply with the law. So if Amendment 20 is brought in as drafted, there is a legal requirement for the solicitor to send to a regulated contact centre. Therefore, failure to do so will breach the rules, and therefore it will be treated as professional misconduct. And therefore, there is a pre-existing underlying obligation, and therefore subsection 2 is unnecessary. Now, Presiding Officer, the statute book must always be considered holistically, and we should not be adding to it with repetition of a provision already contained in the legislation which governs the regulation of solicitors. So we will vote yes. Let's make that absolutely clear. But in an ideal world, there might be a manuscript amendment, perhaps with the consent of the Presiding Officer, which could rectify this. But I'll leave that to the Minister to come back on. Thank you.
Thank you very much, Mr Kerr. I call James Kelly to be followed by James Kelly.
Thank you, Presiding Officer. I rise to support all the amendments in this group. The regulation of contact centres was a theme in the committee's evidence on this bill, and it also featured heavily in the stage 1 debate. The main themes that these amendments seek to address are the protection of the child, ensuring that if a child is left at a contact centre, they do so in an environment that is a safe one. As part of that, there's got to be clear responsibility and accountability of those who are in charge and who are running the contact centres and who have got the responsibility for the duty of care to a child in that situation. Allied to that, I think it's important that people have appropriate qualifications in order to carry this out. And I think the points that Bob Doris made in terms of disabled access are very, very valid ones and need to be addressed. All these points strengthen the fact that referrals must be made to a regulated contact centre, and from that I welcome the work that the Minister has done in response to my amendment at stage 2. in stipulating that referrals by solicitors have got to be made to regulated contact centres. And I think there's got to be strong. We heard a lot of evidence about the issues around this, and I think that's why the section is in there that states that it's a misconduct issue if the referral is not made to a contact centre, so a regulated contact centre. So I support all the amendments, and I welcome particularly the work that the Minister has done in relation to Amendment 20.
Thank you very much. And I call on Neil Findlay to wind up in this group and to press withdraw Amendment 3.
Nothing to add, Presiding Officer, and we'll just move ahead.
Thank you. So the question is that Amendment 3 be agreed to. Are we all agreed? No. We're not agreed to. So we're going to move to a division. Again, this is the first division of the group. It will be a 1-minute division. So members may press their buttons now. And if there are... Okay. Is that good? Again, I think we're losing we're going to just suspend temporarily. We're going to rerun that vote because we're having difficulty again with the Wi-Fi. So we're going to suspend temporarily. Ms Graham, we're suspended, so but I can hear you.
Actually, some of us voted. The vote came up and we voted.
That's right. People did vote, but don't worry, we're going to run the vote again. What happened was... We're currently, just so members are aware, we are currently... Just to let members know, broadcast is coming back on. We're going to resume in about 30 seconds. So if members want to take their seats. In fact, we're ready to go now. So members online as well, in case you were unclear, that vote, I'm going to run that vote again. So the question is on Amendment 3 in Neil Findlay's name. So the vote is on Amendment 3 in Neil Findlay's name. It's a division. We're going to have a 1-minute vote and members may vote now. The result of the vote on Amendment 3 in the name of Neil Findlay is yes 23, no 98. There were no abstentions. The amendment is therefore not agreed. I call Amendment 4 in the name of Neil Findlay. Neil Findlay to move or not move?
Moved.
That is moved. The question is that Amendment 4 be agreed to. Are we all agreed? No. Or not agreed? We'll move to a division on Amendment 4. This will be a 1-minute division. A 1-minute division. The result of the vote on Amendment number 4 in the name of Neil Findlay is yes 22, no 99. There were no abstentions. The amendment is therefore not agreed. Can I call Amendment 5 in the name of Neil Findlay? Neil Findlay to move?
Move.
That is moved. The question is that Amendment 5 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a division on Amendment 5 and again this will be a 1-minute division. Amendment 5. Members may vote now. The result of the vote on amendment number 5 in the name of Neil Findlay is yes 28, no 93. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 17 in the name of the Minister? Minister to move?
Moved.
Thank you. The question is that amendment 17 be agreed to. Are we agreed? Yes. We are agreed. Can I call amendment 18? Minister to move?
Moved.
Thank you. The question is that amendment 18 be agreed to. Are we all agreed? Yes. We are all agreed. Can I call amendment 19? Minister to move formally?
Moved.
Thank you. The question is that amendment 19 be agreed. Are we all agreed? Yes. We are agreed. Can I call amendment 41 in the name of Bob Doris? Bob Doris to move?
Moved.
That is moved. The question is that amendment 41 be agreed to. Are we all agreed? Yes. That is agreed. Can I call amendment 6 in the name of Neil Findlay? Neil Findlay to move?
Moved.
That is moved. The question is that amendment 6 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a division on amendment 6. Again, this will be a 1-minute division. Members may vote now. The result of the vote on amendment number 6 in the name of Neil Findlay is yes 33, no 86. There were no abstentions. The amendment is therefore not agreed. I call amendment 42 in the name of the Minister. Minister to move formally.
Moved.
Thank you. The question is that amendment 42 be agreed to. Are we all agreed? Yes. We are agreed. Can I call amendment 7 in the name of Neil Findlay? Neil Findlay to move.
Moved.
Thank you. The question is that amendment 7 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote on amendment 7. Again, this will be a 1-minute division on amendment 7. Thank you. The result of the vote on amendment number 7 in the name of Neil Findlay is yes 28, no 92. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 20 in the name of the Minister? Minister to move?
Moved.
That is moved. The question is that amendment 20 be agreed to. Are we all agreed? Yes. We are agreed. Now, before we move to Group 7, I'm going to take a short comfort break. So if members can come back for 17:40, a 10-minute comfort break, 17:40. Parliament is suspended. So members, we're going to be resuming shortly. Thank you, members. So if members will resume their seats, we are going to resume business. Now we're picking up from Group 7. This is on the promotion of contact between children and others. Can I call Amendment 43 in the name of Rona Mackay? This is grouped with Amendments 22, 44 and 45. Rona Mackay to speak to and move Amendment 43.
Thank you, Presiding Officer. Amendment 43 is very straightforward and it's purely about terminology. I was astonished to see such archaic language as half-blood and whole blood in 21st century legislation when describing family relationships. I submitted an amendment relating to this at stage 2 but didn't move it at the time because the Minister agreed that she and her officials would work with me to agree on more appropriate terminology. I'm pleased that this has happened and we now have a much better form of words. And that's... Do you want me to go on to Amendment 44?
Yes, please, Ms Mackay.
Which takes me to Amendment 44. The new form of words to replace half-blood and whole blood is two people are siblings if they have at least one parent in common. In my view, this is far more realistic to reflect family relationships in 2020 and seems somehow much less offensive than half-blood and whole blood. This leads on to Amendment 45, which relates to contact with people with whom the child has an attachment. Studies have shown that children form attachments with those who have a significant caring presence in their lives. Attachments are, of course, crucial for the healthy development of young people. These people can be a relevant person in relation to the child, a sibling, or any other person with whom the child has lived with and with whom the child has an ongoing relationship. This, of course, relates back to Amendment 44, which states that two people are siblings if they have at least one parent in common. Presiding Officer, sibling contact, where appropriate and without risk, is absolutely crucial to maintain. During stage 1, we heard enormously powerful evidence of this from a care-experienced youngster who was estranged from his sibling and had limited supervised contact. This merely heaped trauma on top of trauma for him, and it had to be addressed. This amendment also, of course, importantly impacts positively on adoptive parents who are in every sense a legal parent and guardian, and the new definition will help to cement relationships in extended families. So in conclusion, I hope these amendments help to bring the meaning and terminology of this legislation up to date to reflect modern family relationships without any blurring of the lines when it comes to contact and role models in a child's life.
Thank you, Ms Mackay. Can I call Liam MacArthur to speak to Amendment 22 and the other amendments in this group?
Thanks very much, Presiding Officer. Can I start by welcoming the amendments from Rhoda Mackay in this group? They issue of sibling contact, as Rona Mackay indicated, was the focus of perhaps the most emotional and powerful evidence session the committee held in relation to this bill, and I would again pay tribute to Oisin for his personal testimony. Whether the changes proposed go far enough, time will tell, but I certainly welcome them and thank Rona Mackay for her efforts on this important issue. Turning to my own Amendment 22, again this is a reprise of something I moved at stage 2, where I was supported by Jeremy Balfour and Fulton McGregor. As I said, at stage 2, foster care allows children to develop valuable relationships. Keeping in touch with the people they love and trust is important for children and young people as they move through or even out of the care system. It's also the case, however, that for many, the relationships they develop with their foster carers are not prioritised or supported. In some cases, children and foster carers are even prevented from managing contact due to the outdated belief that children must break their attachments in order to make new ones. As I said earlier, I absolutely accept the centrality of taking decisions in the best interest of the child, but it does seem perverse to abruptly end supportive relationships, which can only risk leaving a child feeling abandoned and rejected, and perhaps less able to form those relationships in future. That seems to run wholly counter to the central principles of this bill. From my discussions with the Minister, I do though recognise that making changes on the face of the bill could be problematic. It may therefore be more appropriate to address the concerns raised by the fostering network and foster carers themselves by way of guidance. I'm grateful again to the Minister for sharing with me the draft guidance that has already been prepared. I know from my discussions with the fostering network that they believe that this will be a really positive step forward in the right direction. I note in particular the acknowledgement in the draft guidance that a child's needs, including their emotional well-being, are the paramount consideration, and relationship with former caregivers should be maintained wherever appropriate and for as long as is appropriate, tailored to the needs of the child. It is also stated that keeping in touch after a child moves family should, if appropriate, be routinely considered part of the responsibility of a carer, and carers must be supported by professionals to carry this out as required. I appreciate that further consultation on this draft guidance will need to take place, but I very much welcome the strides that have been made, and on that basis will not be moving my Amendment 22. But can I conclude, Presiding Officer, by recording my thanks to the Fostering Network for their efforts in highlighting this issue, and to foster carers for the invaluable work they do, which may not always get the recognition that it deserves. Thank you.
Thank you very much. Can I call Liam Kerr to be followed by the Minister?
In this group, bar Amendment 22. I think Rona Mackay's points are well made, and associate myself with Liam MacArthur's thoughts on her particular amendments. My issue with Amendment 22 is very similar to my comments earlier, and I'm pleased to note that Mr MacArthur will not move it, though I appreciate again that he comes from exactly a very understandable place when bringing it forward. Thank you.
Thank you very much, Mr Kerr. And I call the Minister, Ash Denham.
Thank you, Presiding Officer. So for Amendments 43, 44 and 45, I am grateful to the member for bringing these amendments, which were highlighted at committee and also at stage 2, as necessary to modernise the language that we're using in the bill with reference to siblings. The amendment ensures that the sibling contact duties created by the bill extend to half-siblings, but uses accessible and modern language to do so. Instead of referring to blood, the amendments refer to having at least one parent in common. The word parent encompasses biological parents, adoptive parents, and those who are deemed to be parents through the law of assisted reproduction. And the amendments do not change the situation of children who are not siblings, but who have sibling-like relationships, and they will continue to be included with the duties. I appreciate on Amendment 22 the reasons for the member lodging this amendment, and I fully understand that maintaining a child's link with people important to them can be beneficial to them as they grow and develop, and for this reason my officials are engaging with stakeholders to strengthen the guidance in this area, which has already been shared in draft with key organisations for their feedback and comment. And I consider that guidance is, in this instance, is the best way to support children in this area, given the need for a sensitive and often a nuanced approach to supporting these important relationships. And I note the member has not moved this amendment.
Thank you very much. And I call Rona Mackay to wind up in this group and to press or withdraw Amendment 43.
Press, Presiding Officer.
Thank you very much. So the question is that Amendment 43 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 22, Liam MacArthur, to confirm he is not moving?
Not moving.
That is not moved. Amendment 22. Can I call Amendment 44, Rona Mackay, to move?
Move, Presiding Officer.
Thank you very much. The question is that Amendment 44 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 45, Rona Mackay, to move?
Move, Presiding Officer.
Thank you. The question is that Amendment 45 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. Turning now to Group 8. This is on alternative methods of dispute resolution. I call Amendment 24 in the name of the Minister, grouped with Amendments 25, 32 and 33. Minister, to move Amendment 24 and speak to all amendments in this group.
Thank you, Presiding Officer. This group of amendments remove and replace sections 11A and 11B of the bill on funding for alternative dispute resolution, which were added to the bill at stage 2. The new provisions achieve the policy aims of section 11A and 11B, but address issues that might have caused problems in practice. I appreciate the engagement I've had with Margaret Mitchell on these amendments, and I know that alternative dispute resolution has been a subject that has been of great interest to her for many years now. Amendment 32 requires Scottish ministers to assist people to meet the costs of alternative dispute resolution, and the Scottish Government recognises the valuable role that ADR can play, also obviously including mediation. One of the key aims of the bill is to ensure that the voice of the child at the centre of any dispute is heard, and I think it's important that if parties decide to use ADR, that the voice of the child is not lost. So the amendment insists that public funding is only available to those ADR processes that take on board the views of the child to at least the same extent as a court is required to do, as we've already discussed what this bill says about the requirement for the courts. So Amendment 33 places a duty on Scottish ministers to establish a pilot scheme under which parties to court proceedings will be required to attend awareness meetings or alternative dispute resolution processes. And to be clear, these meetings are not themselves ADR, but an opportunity for parties to learn about the availability of alternatives to court. The amendment makes clear that cases in which there has been domestic abuse are not to be taken under the pilot scheme, and I'm sure members will agree with me that that would not be appropriate. And I will also commit to working with organisations which support victims of domestic abuse when I am establishing the pilot. Clearly, it's also very important for the pilot to be properly evaluated, and I would expect any evaluation to look at statistics on the number of parties attending the awareness meetings, as well as the outcome of those cases. And the evaluations will include interviews with people who've participated and with the ADR providers. And I move Amendment 24.
Thank you very much. And I call on Margaret Mitchell.
Thank you, Presiding Officer. I'm pleased to speak in support of the alternative methods of dispute amendments in this group. And I thank the Minister for working with me to ensure my amendments, which were passed at stage 2 and which provide for a mediation pilot scheme and legal aid funding, are improved. Amendment 32 and 33 allow for greater flexibility for ministers to provide that financial assistance for parties seeking to use ADR. For example, it could allow SLAB to make grant payments to relevant bodies for the provision of ADR, helping increase the availability of services, but also providing value for money. It also ensures that in the mediation process, there is a clause stipulating that the voice of the child and young person is heard when decisions are taken which affect them. This has been achieved by including the duty to evaluate the pilot and to analyse the outcomes for children at the centre of the dispute. I know that previously, Relationship Scotland and CAM have approached the Scottish Government about the implementation of a similar pilot scheme, and I hope the Scottish Government will draw on their expertise of these organisations in designing and implementing the pilot. Finally, I sincerely hope that combined these amendments will help lead to the early resolution of disputes, allow for more bespoke and family-focused solutions, and prevent children from experiencing the stress and trauma of court, especially as it's widely recognised and the Justice Committee heard from stakeholders during stage 1 evidence that courts are rarely the best place to resolve family disputes.
Can I ask whether the Minister wishes to add any comments about... Oh, sorry, beg your pardon. James Kelly first. James Kelly.
Thank you, Presiding Officer. Just briefly, support the amendments in this group. Recognise that there was some issues raised by Scottish Women's Aid and also Children's First, just in terms of protection for victims of domestic abuse. I think the pilot is the correct way to go, and I support the Minister's given the assurance to work along with Scottish Women's Aid and Children First to ensure that some of their concerns are addressed, and also pay tribute to Margaret Mitchell for the work she's done on this, and also the work she's put in as convener of the Justice Committee.
Thank you, Mr McKelly. Lee MacArthur.
Presiding Officer, very much to echo the comments that James Kelly has just made. I moved similar amendments on ADR at stage 2. I'm very grateful to Margaret Mitchell for the work she's put in on this, working collaboratively with the government. I think the concerns that James Kelly's just referred to needed addressing, and we seem to be in a much better place going forward. So again, I thank them and confirm our support.
Thank you very much. And does the Minister wish to add any comments? In that case, we will move straight to the vote. The question is that Amendment 24 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 25 in the name of the Minister? Minister to move.
Moved.
Thank you. The question is that Amendment 25 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 26 in the name of Lee MacArthur? This was debated earlier with Amendment 9. Lee MacArthur to move or not move? That is not moved. Can I call Amendment 46, also in the name of Lee MacArthur? This was debated with Amendment 36. Lee MacArthur again to move or not move?
Moved.
That is moved. So the question is that Amendment 46 be agreed to. Are we all agreed? Yes. We're not agreed. We're going to move to division on Amendment 46 in the name of Lee MacArthur. This will be a 1-minute division, and members may cast their votes now. That's what happening. Apologies, colleagues, there are too many members who aren't able to vote, so I'm going to suspend proceedings and rerun that vote again. Proceedings are suspended temporarily. Thank you, members. That is us back in session again. We were interrupted there in the middle of calling a vote on Amendment 46 in the name of Liam MacArthur. So we're going to move to the division again. So the question is that Amendment 46 be agreed to. Members may cast their votes now on Amendment 46. This will be a 1-minute division. The result of the vote on amendment number 46 in the name of Liam MacArthur is yes 89, no 29. There were no abstentions. The amendment is therefore agreed. We're going to turn now to Group 9, which is the duty to ensure availability of child advocacy services. Can I call Amendment 27 in the name of the Minister, grouped with Amendments 28, 29 and 30. Minister to move Amendment 27 and speak to all the amendments in this group.
So the amendments in this group make minor and technical adjustments to the provision agreed at stage 2, which places a duty on Scottish ministers to make child advocacy services available. They simply move the place at which the bill will insert text into the 95 Children's Act for a better fit with the Act structure, and they make a technical correction to the way that Section 11 cases are described. And I move Amendment 27.
Thank you very much, Minister. And I know colleagues have indicated they wish to speak in this section, so we'll move straight to the vote. The question is that Amendment 27 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 28. Minister to move.
Moved.
Thank you. The question is that Amendment 28 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 29. Minister to move.
Moved.
Thank you very much. The question is that Amendment 29 be agreed to. Are we all agreed? Yes. Thank you. We are agreed. Call Amendment 30. Minister to move.
Moved.
Thank you. The question is that Amendment 30 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 31. Minister to move.
Moved.
Thank you very much. The question is that Amendment 31 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 32. Minister to move.
Moved.
Thank you. The question is that Amendment 32 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendment 33. Minister to move.
Moved.
Thank you. The question is that Amendment 33 be agreed to. Are we all agreed? Yes. We are agreed. We're going to turn now to Group 10. This is the duty to ensure a system of redress. Can I call Amendment 47 in the name of John Finney in a group on its own? John Finney to move and speak to Amendment 47.
Thank you very much indeed, Presiding Officer. I don't think anyone doubts that the bill is a positive step forward in acknowledging children's rights, and it's further step towards enhancing compliance with the UN Convention on the Rights of the Child. Now, as we've heard across the Chamber, parliamentarians are very familiar with the concern that children's views are not always heard in disputes about contact, and it's certainly the view of Scottish Women's Aid, Children First, Children's Commissioner and others that children must be active participants about decisions about their future and not casual observers. The problems that have been alluded to are partly the result of our adversarial legal system that deals with disputes about contact. That's a system that sees contacts as a dispute between adults, that tries to keep children out of the dispute, and where children rarely have any legal status in the dispute, in which children's rights risk being at the discretion and behest of adults, whether parents or indeed court personnel, where children's experiences are all too often disempowering and distressing as cases proceed through the legal system. So the bill's real progress in children's participation rights, the fundamental change this bill derives is the presumption a child has capacity to express a view. The bill requires the court to explain its decision. It requires a parent to, but it places a duty on Scottish ministers to ensure the availability of child advocacy services, something children consistently tell us would help the most. Now, there is a process for appeals at the moment, but of course it's designed by and for adults and it's not accessible to children. It requires a parent to raise an appeal on behalf of a child, or for a child to become party to the dispute and then to access legal aid for their own independent representation. Becoming party to the dispute is not an easy task for a child, especially when their access to legal aid depends upon parental income, and children may be expressing views that are contrary to those of a parent. So without an accessible system of redress, children struggle to claim their rights to participate in major decisions that affect their lives. If a child had not been given the choice to give their views, they currently find it very hard to reverse that decision. If a court report is written about a child, the child has no way to disagree with what it says. And research has shown that some children felt their views were misrepresented or the substance of them had changed in the reporting to the court. One child that we heard at the Justice Committee urged those tasked with taking children's views to think about what you're writing. You changed what I said. That's a quote from them. Of course, without an accessible mechanism for redress, children cannot challenge this. My amendment has the potential to bolster children's rights further, to make rights both real and accessible to children. And if passed, it will require Scottish ministers to introduce a system of redress for children should children feel their participation rights have been breached. The amendment requires Scottish ministers to make regulations. It's not prescriptive about the contents, as it says, as they consider necessary and expedience to establish an effective child-sensitive redress scheme. And for that to be meaningful, of course, there will be engagement, not least with young people. So hopefully the adoption of best practice, a rights-based approach to all proceedings, will mean this provision is rarely used. However, I'm not in believing it's nonetheless necessary. Subparagraph 3 talks about where actions have been taken for the purpose of securing the child's best interests. So this isn't about a blanket approach. It's not about a grievance approach. Decisions will have to be taken that inevitably a child or children won't agree with. It is about an evidenced, rights-based approach to all decisions. It will complement the other provisions in the bill. The members will note that Scottish Women's Aid, Children First and the Children's Commissioners and others have endorsed this approach, and members will be cited in the widely circulated blog by academics Fiona Morrison and Kay Tisdall. Very clearly, it would afford children's participation participation rights, greater status. As stated in the UN Committee on the Rights of the Child General Comment on the implementation, for rights to have meaning, effective remedies must be available to redress violations. This amendment has the potential to make children's rights real in disputes about contact and to take us a step closer towards... I can? Yeah.
Liam Kerr.
Thank you. I know you're winding up, Mr Finney. It's just purely, I think this is the first time we've seen this amendment. Can I ask, why didn't you introduce this earlier in the process?
John Finney.
I think it's a very reasonable intervention to make, because I wasn't approached to make it. We were, all the organisations that pay attention to our bill have regard to how things formulate as we go through. It's very clear to all these eminent people, the Children's Commissioner, that there is a gap that this would fill. As I said in my speech, it's not that there isn't a system of appeal at the moment, it is that it's adult-focused. And if we are to make this entirely child-focused and move towards UNCRC compliance, then this is the way to do it. Yes, indeed.
Neil Findlay.
Helpful to Mr Finney. That argument that Liam Kerr puts forward is a red herring, because you're allowed to bring forward amendments at any stage. But also, when the bill went through earlier in the year, Murdo Fraser brought through an entire members' bill at stage 3 and inserted it into a piece of legislation, and we heard no complaints from Mr Kerr at that point.
John Finney.
Thank you, President Officer. I hear what Mr Findlay says. I'm not wanting to get involved in a dispute about anything other than the merits of this amendment. That's what's important here. Significant people who have regard to a rights-based approach for children have commended this, and I commend this to members to support. Thank you very much.
Thank you very much, Mr Finney. And I call on Liam Kerr.
Thank you, Presiding Officer. I'm very sympathetic to what Mr Finney is trying to do here. I'd listened very carefully to his thoughts, and my objection was, I wasn't making an objection, Mr Finney. I think it's a very important point about when we bring in amendments, because I do accept that Amendment 47 is looking to address what appears to be a gap in the bill, and due to its emphasis on achieving the best outcome for the child, I absolutely support its intentions. My concern is that this is a really significant amendment to be bringing forward at this stage. So just to keep my remarks very brief, just very simply, that I don't see a definition of redress, for example. I don't think there's been any consultation done on this amendment previously. And just for one of the representations that we've received in favour of the amendment says, look, in order to effectively meet the obligation that's being imposed, the Scottish Government would need to work out how such a system would go forward and operate, and it would have to involve the young people. There's a whole lot of work to be done here. So it's my view that amendments of this extent need to be subject to more consultation, to more scrutiny than introduction at this stage allows. So I'm afraid at this stage, my objections to the amendment stand.
And I call James Kelly to be followed by the Minister.
Thank you, Presiding Officer. I want to speak in support of John Finney's amendment. I think it's an important amendment because if you look at the UN CRC, effectively, this bill is very good and it's welcomed by members across the chamber. But if we pass it without this amendment, then it's short in terms of the UN CRC standards in relation to a system of redress. Yeah, sure.
Minister Ashton.
I would point out to the member, just for clarity now, that a requirement for child-friendly redress is not in the UN CRC itself, but it's in general comments, and it's in general comment 5.
James Kelly.
I think the point remains that if we're passing a children's bill, there should be a system of redress in there, and we would be failing on our obligation as a parliament not to take a serious look at this amendment and to include it in the final bill. So I welcome the fact that John... Yeah, sure.
Liam Kerr. Yeah, because I think that's a really important point, Mr Kelly. And, you know, deep down, I would like this to go through, but we haven't scrutinised it. We haven't taken the time to take a step back like we would normally do at stage 2 and really examine what it is we're passing today, and that's why I have such a concern.
James Kelly.
I'd simply point out to you that if we accepted the arguments that yourself and the Minister are putting across, then we simply put our heads in the sand and we miss an opportunity, and we're therefore not doing our best to serve the children that this bill sets out to look after. So, in conclusion, I support John Finney's amendment. It's well supported by Scottish Women's Aid, by Children's First, by the Children's Commissioner. So there's substantial support for this. And I think including this in the bill at stage 3 completes the bill and makes it a lot more comprehensive. So I would urge Parliament to support it.
And I call on the Minister.
Thank you, Presiding Officer. On Amendment 47, I do appreciate the concerns raised by John Finney, and I do agree with him that where a child or a young person has concerns about how their court case has been handled, that these need to be taken seriously and they need to be listened to. And ensuring that the views of the child are heard is obviously one of the key aims of the bill. However, I am unable to support the member's amendment. It comes very late in the day, as has been noted by Mr Kerr, and it has not had the opportunity to be considered earlier in the bill process. It wasn't raised at stage 2 in debating the bill, and there are a number of issues that I believe need to be clarified through consultation, parliamentary debate, before an amendment such as this finds its way onto the statute book. So, for a start, it is not clear in the amendment what a redress scheme would entail. So I'd like to ask the member what he thinks would be appropriate redress if the child feels their views haven't been heard in contact or residence. So would it be financial compensation? Is it a complaints mechanism? Would it be an apology? Or is it perhaps a reopening of the decision? How would that sit alongside the existing appeal process? Whether the amendment would affect the ability to vary the order? I will.
John Finney.
Thank you, President Officer. I'll cover a lot of these points in the summing up, but can the Minister say then, because these are all to be flushed out in the regulations, can the member say, if these concerns are being taken seriously, does the Minister take issue with what I said, that at the moment it's very much an adult-based approach that's taken? It's a system of appeal that's been talked about. Call it redress. The terms in common parlance, but I'll come back to that. But if it's to be taken seriously, how are they taken seriously at the moment when adults predominate in the system?
I think that's a very good point. I think the point I'm trying to make at this point in my remarks is that the redress is not defined enough. It doesn't provide enough clarity. And I think it's all very well for the member to say this could be worked out in regulations, but this would be an entirely new scheme. So I don't think it's appropriate at that point. But on the member's point about is this taken seriously at the moment? Is this child-friendly at the moment? No, I would agree with you. It's not. That's why we're putting the mechanisms in the bill that we are to include child-friendly complaint mechanisms. So, and I'll go on to talk about those in a moment. So I do take on board the member's point, but I think we are addressing this with what is on the face of the bill. So, the extent to which a redress scheme may cut across existing remedies, if they're unhappy about the procedure or the outcome of the court order, is something that would need to be considered very carefully. And a child can already apply to court to vary the order. And there are organisations such as Clan Child Law and the Scottish Child Law Centre, which provide representations to children. So for younger children, a curator ad litem could be appointed to represent the child's interests, and we are proposing to regulate them in a similar way to the regulation of child welfare reporters. And so I would reassure the member and also the Chamber that the government is doing work in this area. And as we've already discussed today, the bill will improve the ways in which children can effectively participate in Section 11 cases. The government has shared guidance for children on child welfare reporters with key stakeholders, and that includes information about how a child can complain and about the conduct of a child welfare reporter, which I believe does address one of the points that Mr Finney made in his opening remarks. With the regulation of child welfare reporters, the Scottish Government has plans in place to ensure there is a child-friendly complaints mechanism in place, and I would be very happy to discuss that further with the member and to reassure him again that this will be part of a full public consultation, and the eligibility criteria and the standards for child welfare reporters will be part of that. So in relation to contact centres, the Scottish Government will ensure that once regulated, there is also a child-friendly complaints mechanism there as well, and that the body appointed to oversee the contact centre can act on any complaints that are raised. Section 16 of the bill around failure to comply and with an order will mean that if a child refuses, for example, to have contact with a parent, then the court will now be required to investigate the reasons for this and to seek the views of the child. Section 15 of the bill requires the court to explain decisions to a child in child-friendly language as well. Section 15A of the bill requires Scottish ministers to establish child advocacy services as they see necessary to facilitate participation. And members have already voted on Liam MacArthur's amendment number 48, requiring the effectiveness of the bill's provisions in facilitating children's participation to be reviewed in 5 years' time. And that requirement for a review will ensure that any future government will look again to see whether these reforms have worked out. And if it finds that there are further improvements that need to be made, it can provide both a prompt evidence base to start seriously looking at that in a considered way. So given the uncertainties of what I've laid out around Amendment 47, what it would mean in practice, and given the work that is already underway to enhance children's rights, I would ask members to reject this amendment.
Thank you. I call on John Finney to wind up in this group and to press withdraw his amendment.
Thank you very much indeed, Presiding Officer. Can I thank all the participants in this particular section of the debate? I think I agree with a lot of what's been said. There is a lack of definition. There has been no consultation on the regulations. But that's precisely why at subparagraph 4 it talks about being subject to affirmative procedure. There's no doubt that there would be scrutiny. There's no doubt that there's a gap. The issue about a whole lot of work, of course there's a whole lot of work, and the Minister would be wrong to construe anything I've said. Indeed, I think I've actually particularly said this has been a great step forward. Nonetheless, and accepting what you've said about a child-friendly system, The reality is that significant children's charities, and importantly the Children's Commissioner, have identified a gap. Again, hopefully I said correctly that it's a general comment 1 that is the source of that reference about the shortcomings. I don't doubt that this issue will be revisited at some future point. We've already in this session talked about Barnhouse and the progress that's going to be made and the child-centred approach that's been taken. The present system has this gap. This is an opportunity to fill it. And I hope members take that opportunity and vote for the amendment. Thank you very much.
Thank you very much, Mr Finney. So the question is that Amendment 47 be agreed to. Are we all agreed? No. We're not agreed. We're going to move to a vote now. I would just encourage members, before they do, just refresh your screens. If there's any difficulty, don't log out or log in. Just refresh your screen, and that should bring the page back up again. So we're going to move to a vote on Amendment 47. This will be a 1 minute. Well, let's just try it and see if we can't. If we can't, we're going to go for. Okay, I'll just give a few seconds before we call the vote. But members should try and refresh their screen. Put your hand up and call some support over if you can't refresh your screen or you don't get the voting page up.
People did vote. The votes had to run by this.
Can I just check, if any members do not have the vote not open page, can you put your hand up? Okay, so we are ready to go. We have one. Okay, we're going to try and run the vote again. This is a vote on Amendment 47 in the name of John Finney. This will be a 1 minute vote and members may cast their votes now. The result of the vote on amendment number 47 in the name of John Finney is yes 31, no 86. There were no abstentions. The amendment is therefore not agreed. Now, before we move to the final group, I'm conscious that decision time is scheduled for 6:30. We're almost there. So I'm minded to accept a motion without notice to move decision time to 7 o'clock. Business managers have consulted and we've agreed to shorten the debate following this amendment stage. Could I ask the Minister for Parliamentary Business to move a motion?
Move, Presiding Officer.
Thank you. That's to bring the decision time to 7 o'clock. Our members agreed to move decision time to 7 o'clock. Are we all agreed? Yes. We are agreed. And turn now to Group 11, Children's Hearings Opportunity to Participate. Can I call Amendment 34 in the name of the Minister in a group on its own? Minister to move and speak to Amendment 34.
I move Amendment 34, which will have a positive impact on children and young people who are cared for away from home. The amendment would enable an individual to participate in a children's hearing where they are not a relevant person, but they do meet the criteria as a qualifying sibling or relative. These provisions, together with revised procedural rules, will allow certain rights for individuals, such as being notified of a hearing, being provided with paperwork relevant to them, and being able to attend and be represented. And the detail on these rights will be set out in rules which will be consulted upon. The provisions do not allow for siblings' right of appeal against the hearings decision. The UK Supreme Court, in the case of ABC and XY versus the principal reporter in June this year, made it clear that the system was already flexible and capable of being operated compliantly with ECHR for siblings. And I hope members agree that an appeal right overall could be disadvantageous both to the child at the centre and siblings. Court proceedings are not the most appropriate forum for disputes over how long brothers and sisters should see each other. This is better done in the less formal children's hearing environment. Instead, these amendments introduce review provisions which will have the effect of allowing a qualifying sibling or relative to request a further children's hearing as long as 3 months have passed since the making of a compulsory supervision order in respect of a child. And this allows the hearing to keep the relationship between the child and their siblings under close review if needed. And it permits quick adjustments to be made to measures in the child's legal order. The child at the centre of the hearing and the relevant persons already have this review provision. The Independent Care Review have been clear in their promise report that being notified of children's hearings and having an opportunity for meaningful participation in decisions that affect them is crucial to brothers and sisters. And I am delighted to be able to use this bill as a means to achieve that during the first year of the implementation of the promise.
Thank you very much, Minister. And no other members have indicated they wish to contribute. So the question is that Amendment 34 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 48 in the name of Liam MacArthur? This was debated with Amendment 8. Liam MacArthur to move or not move? That is moved. The question is that Amendment 48 be agreed. Are we all agreed? Yes. We are agreed, and that ends consideration of amendments. Now, at this stage, as members will be aware, I'm required under standing orders to decide whether or not, in my view, any provision of the bill relates to a protected subject matter, that is, whether it modifies the electoral system or franchise for Scottish parliamentary elections. In the case of this bill, in my view, it does no such thing. Therefore, the bill does not require a supermajority to be passed at stage 3. So we're going to move on shortly to stage 3. There will just be a very short pause.
The next item of business is a debate on motion 22505 in the name of Ash Denham on Children Scotland Bill. Could I ask members to stop the private chatter, please, and take their places? Parliament has resumed. Parliament has resumed. Would members please take their places? Thank you very much. I'll start again. The next item of business is a debate on motion 22505 in the name of Ash Denham on the Children's Scotland Bill. Would those members who wish to speak in the debate please press the request to speak buttons? And I call on Ash Denham to speak to and move the motion for up to 6 minutes. Please, Minister.
Thank you, Presiding Officer, and I am delighted to open the debate at this final stage of the bill, which seeks to improve our family courts and children's hearings. And I'd like to thank the Justice Committee for its careful examination of the bill and for its very considered Stage 1 report. And I'd also like to thank, in particular, the parliamentary staff for their support in this process and to commend them for rising to the challenges of COVID-19 and putting in place new processes that have enabled scrutiny of this bill to continue during the public health emergency. Many stakeholders and individuals took the time to provide evidence to the Justice Committee on this bill, and the amount of the evidence that the committee received and the responses received as a result of our consultation in 2018 shows that reforming the family courts is an important issue for many people. But let me be clear, our work on improving the family courts is far from complete. There is much left to do, and we will do that as quickly as we can in the current circumstances. I will.
Neil Findlay.
Thanks. I'd also like to thank those who have contributed to the bill. Would the Minister acknowledge that had it not been for my constituent Emma MacDonald bringing the petition to the Petitions Committee, it's unlikely that some of the reforms that we're seeing today would have come through?
Ash Denham.
I'd like to thank all stakeholders who've engaged with this process for their very considered comments, many of which have made their way into the final version of the bill. So the Children's Scotland Act of 1995 is key legislation on contact, residence and other parental responsibilities and rights, and the bill builds on that act. And one of my key aims of the bill was to ensure that the voice of the child is heard, and ultimately the best interests of the child are paramount consideration in any contact or residence case. The bill, as introduced and as amended at Stage 2 and today at Stage 3, furthers the rights of children to participate in proceedings. The presumption that a child aged 12 or over is mature enough to give their views has been replaced with a presumption that all children are capable of giving their views, subject to extremely limited exceptions. And in addition, under the bill, the courts will be required to provide children with an explanation of their decisions. Courts will be required to seek the views of children if an order has not been complied with. And these are radical changes to make the whole process much more child-friendly. It's important that when children give their views, they know what to expect and what will happen to their information. So I'm pleased to have worked with Liam MacArthur and other stakeholders on amendments to the bill in relation to protecting children's private information. And we've also prepared draft guidance to children and young people on speaking to a child welfare reporter. We've sent this to key stakeholders for comment, and I look forward to finalising this important guidance over the coming months. The bill also makes important steps forward for looked after children and their brothers and sisters. And this bill requires local authorities to promote contact between a child and their brothers and sisters, just as they must promote contact with parents if this is possible. In recognition of the consultation responses from children and from young people and organisations that support them, these duties extend beyond biological brothers and sisters to those unrelated to the child, but with whom they have built a relationship that has the character of a sibling. I've put forward in today's amendment new provisions for qualifying siblings and close relatives of a child to be at the centre of a children's hearing, to have opportunity to meaningfully participate in the proceedings. And the aim is to ensure that those closest to the child are able to be supported, to give their views in these important proceedings where they wish to do so. The bill also further protects victims of domestic abuse by ensuring that they're protected in child welfare hearings and by introducing a prohibition on personal conduct of a case where a party has committed a relevant criminal offence. And as I said, this bill is only the start of the process of reforming family courts. Implementation of the bill will take time, and I'll endeavour to commence sections of the bill as soon as it's possible to do so. Some sections will require significant consultation, for example, establishing a register of child welfare reporters and also the regulation of contact centres. Others may be able to be done at a quicker pace. I appreciate that for many people experiencing the family court process, it's important that we make these changes as quickly as possible. And I promise to take forward work on implementation as quickly as we can with the challenges of COVID and Brexit. And I hope that stakeholders will continue to engage with my officials as we take forward the implementation work. Now, in addition to the bill, the Family Justice Modernisation Strategy includes a number of areas for further work that don't require primary legislation. And this includes guidance for parties on going to court, including the alternatives to the court process. And a number of the bill's provisions in some areas of the Family Justice Modernisation Strategy work require court rules. And my officials will be working to develop policy papers for the Family Law Committee of the Scottish Civil Justice Council on those. In conclusion, Presiding Officer, this bill is a significant change in improving the family courts. However, it is only a starting point. Implementation of the bill and the Family Justice Modernisation Strategy will be the next step. And so I move that the Parliament agrees that the Children Scotland Bill be passed.
I call Liam Kerr for up to 5 minutes, please.
Thank you, Presiding Officer. I remind members, just for the avoidance of doubt, I'm a practising solicitor holding certificates with the Law Societies of England, Wales and Scotland. In opening for the Scottish Conservatives in this debate on the Children's Scotland Bill, I confirm that we will vote in favour of its passing at decision time tonight. The stated aims are to ensure the views of the child are heard in contact residence cases, protect victims of domestic abuse and their children, ensure the best interests of the child are at the centre of contact residence cases, and ensure compliance with the UNCRC. And I think we've achieved that. The process getting to this stage has been long, productive and collaborative, and it has been good to work cross-party on so many of these issues. It is notable that throughout the consultation, evidence-taking and the stages, we have moved from what I think was quite a strong start, actually, to a finished product that I think we can all be proud of. And that's only been possible because of those who gave evidence, written and orally throughout this process, and to the many organisations and individuals who provided informed and informative briefings for us, both on the amendments and the overall bill. These are hugely helpful, and as viewers and colleagues will have noted this afternoon, certainly help clarify my thoughts on various amendments, and no doubt those of colleagues throughout the chamber. Now, I said in stage one that it was the power of evidence that was given by the witnesses that helped remind me of the deep responsibility that we all share to get this right. I believe we have, and I hope the debate throughout and today has enabled all contributors to feel that they have been listened to. And I think we have all been listening. The fact that so many amendments have been proposed and made suggests so. And I know that several votes today were swung by the quality of the submissions that we've been given and the quality of the contributions that we heard this afternoon. But in particular, I remember an unlikely alliance arising following the stage one debate when Neil Finlay and I asked the Minister to remove the word practicable from section 10 on the basis of some extraordinary testimony from Celsius, Who Cares Scotland and Oisin King, amongst others. And credit to the Minister. She met with us after and made the amendment. On a similar note, Rona Mackay got through an amendment earlier on referring to the whole blood, which I indicated earlier in the evidence taking that I also was concerned with. So I was very pleased to see that. Within that note of consensus, however, I gently and very briefly wish to make a point about amendments, mainly because I think John Finney's amendment right at the end there was pretty key. I know it is perfectly permissible to bring forward novel amendments at stage 3, but I don't think it's prudent. And I don't like it because I think the risk is we end up with bad or incomplete law. And I cite, by way of example, today's Amendment 34, I think the last one that we looked at, which clan child law, note, is a step in the right direction, but it doesn't seem to have a right of appeal. Had that been introduced at an earlier stage, I think we might have dealt with it. Mr Finney.
John Finney.
Yep, thank you very much, President. I'm very grateful to Mr Kerr taking an intervention. Does he not see this danger in saying that? I wanted to steer the discussion on the merits of the individual, but there's a real danger in saying, don't bring something at stage 3. A real danger, particularly given the setup we have here, a unicameral setup.
Liam Kerr.
Yeah, I'm very grateful, but I think that's not what I'm saying. I'm not saying don't bring stuff forward at stage 3, but I am referring to the unicameral setup that he refers to, because there is a process here. And because we have a unicameral setup, the importance of the committee stage and stage 2 is elevated such that when we have issues as important as those that you, John Finney, has brought forward today, they have to be tested at stage 2. They have to be subjected to evidence, and they have to be fully considered. Yes, Mr Finlay.
Neil Finlay.
Can we take it from that this will become a point of principle for Mr Kerr and the Conservatives, that if a future anyone brings forward something at stage 3, it will be a point of principle for Mr Kerr that he will object to it and oppose it because it has not gone through that scrutiny process? I think he has to make himself very clear on this.
If you could answer that and then wind up, please, Mr Kerr.
I think Mr Finlay is well aware that I will consider everything on its merits, and I stick to the same point that I made to Mr Finney, that the way this Parliament is set up merits looking at things in full detail at stage 2. And in conclusion, we're very late, Mr Finlay, and the presiding officer is not terribly chuffed.
I can confirm that the presiding officer is not terribly chuffed. If you could wind up, please.
Thank you, Presiding Officer. Presiding Officer, I came to the bill very much from a standing start. I hadn't done anything in the family courts except for some very second-hand personal experience since the start of my legal career some 2 decades ago. But I think by working together on this bill, politicians from across the chamber have been able to contribute to legislation that I really believe will better protect the interests of children in the Scottish legal system and ensure that they are able to contribute to that system wherever they wish to do so. Inevitably, different parties have different viewpoints, different interests, and we'll see this bill as leaning too far in certain directions or not far enough in others. But for legislation of this kind, the best solution is always to be found through an approach that allows compromise. And, Presiding Officer, it is precisely thanks to that compromise that I believe this bill will achieve what it set out to do, and we shall vote for it at decision time tonight.
Can I just draw members' attention to the fact that decision time doesn't look like it will be 7 o'clock at all unless contributions are drastically cut, and even then. So I now call on James Kelly for up to 4 minutes, please.
Okay, Deputy Presiding Officer, bearing that in mind, I'll try and curtail my remarks. Scottish Labour will be supporting the bill at decision time tonight. I think it's a mark of the importance of the issues here, the number of expressions of interest there's been throughout the 3 stages as the bill's proceeded, and a number of briefings that we've received and representations from stakeholders. And that shows you how important this bill is. Primarily it was brought forward because it was recognised that the current legislation wasn't adequate in terms of representing children, and I think there's been some key reforms brought in there, you know, like for example the presumption, or doing away with the presumption on 12 plus for a child to have a view. I think that's been very important. That came across very powerfully at the committee. I think it's been important to ensure that in the court setting itself, the voice of the child is placed as a priority, and that was set out in the original legislation and has been strengthened as the amendments have run through. And the addition of protection for vulnerable witnesses is another area which has been important also. One of the big areas that's been concentrated on throughout the debate and featured today was that of child contact centres. And it's clear from the evidence we received and the representations from members that there were real issues around some of the contact centres. And I hope that when this legislation is introduced, particularly strengthening the issue around using regulated contact centres.
Excuse me, Mr Kelly. It's terribly noisy in the back row up there. James Kelly.
Strengthening the position of regulated contact centres, ensuring that there's safety for children in those contact centres and there's a proper setting out of responsibility and accountability for those who are responsible when the child has been passed in. In summing up, I believe that this has been an important piece of legislation that the Parliament's passed. There's been strong engagement from stakeholders and there's been genuine working on the issues across party, and I think that's a good example for legislation going forward. We've got strong legislation and hopefully that will serve the interests of the child well.
John Finney, up to 3 minutes, please.
Thank you very much indeed, Presiding Officer. Like others, I'd like to thank everyone who's been involved in the process here, those who have given us given evidence, the parliamentary staff for assisting, and it's very clear that there's a lot of consideration going into this. We've heard that from everyone. I think the engagement is credit to the Minister. There has been, clearly you can't engage early enough, that's for sure, but it's very clear that we want to make good legislation and we want to address a concern, and the concerns have been articulated by members across this chamber that we're familiar with, both from personal experiences through a constituency mailbag and, some of the phrases, even the series of amendments, the voice of the child. The voice of the child is going to be listened to differently now because there isn't an arbitrary cut-off point that said at this point you're in position to express your views on your entire life in many instances. And I think that's about the quality of people who are taking these views, of course. And I look forward to the ongoing engagement about the child welfare reporters, because I think it's absolutely going to be pivotal in this process. Often many problems come about because people are misunderstood, they're not listened to. I make no apology, I think, for the third time mentioning Yellow, the survivors group, telling us, and I'll put the specs on so as I get it right, think about what you're writing, you changed what I said. Someone's life, someone's future was going to be shaped on a misunderstanding, probably rather than a misrepresentation. So I appreciate, and the Minister's alluded to the fact that there's a family modernisation strategy and that there will be ongoing review. I think many of the things we've touched on here about grandparents, about foster parents, about estranged siblings, they are all brought together if the interests of the child is at the forefront of all the deliberations. I think for me, one of the important aspects of the legislation is the requirement for the court to explain its decisions to a child in the way that a child can understand. As I said when I was speaking about the amendment, this is often seen as a keep the children out of it. That's a phrase that we've all heard when the children are front and centre of the most important decisions affecting them. So I think, as James Kelly, my colleague James Kelly said, that this may well be a model of how to do things. A lot of engagement, a lot of consensus, and I look forward to the legislation that brings children's rights to the forefront, continuing to develop, and to the Scottish Government moving for full incorporation. Meantime, I thank the Minister for her engagement in this and say it is a good bit of legislation. It started off, I think, as Liam Kerr said, started off okay, and it's better for the energy that's gone in. Thank you very much indeed.
Liam MacArthur for up to 3 minutes, please.
Thanks, Deputy Presiding Officer. Having participated remotely in Stage 1 and 2 of this bill, it is nice to take part in the Chamber for Stage 3 proceedings. I join colleagues in thanking all those who helped us in our scrutiny by giving evidence, as well as committee clerk, Spice, and those who helped making remote involvement possible. Scottish Liberal Democrats will, of course, support this bill. We recognise that in cases where a relationship breakdown turns out to be difficult or traumatic, it's invariably the child or children involved who pay the heaviest price. We recognise, too, the importance of ensuring that any decisions that are taken in these circumstances have to be taken on the basis of the best interests of the child. For that to happen, the child's views must be clearly heard and taken into account, and this bill helps ensure this happens more consistently and meaningfully. At the same time, we know that children often confide highly personal information with third-party organisations, which they are reluctant to see shared more widely. At present, This can happen without consent or indeed even consultation. I'm pleased, therefore, that Parliament has supported the safeguards I brought forward, working with the Minister. That will mean that this should only now happen after taking a child's views into consideration and where it's proportionate to do so. It's encouraging too that at stage 2 the committee backed amendments I lodged guaranteeing a child's access to advocacy support. This is fundamental if we're to have any hope of achieving the principal aims of this bill. As Dr Morrison and our colleagues told the committee, the strongest and most consistent request from children and young people in Scotland who've been involved in contested contact proceedings is to have a child support worker. Yet questions remain over the resources allocated to underpin this legislation, particularly in the context of what witnesses referred to as the infrastructure for taking children's views. That's why it's so important that Parliament has put in place a review process that will allow an assessment to be made, amongst other things, as to whether or not children's rights are realised in practice. Another area where I must credit the Minister and our officials for their constructive engagement is in relation to the issue of foster carers. I think the revised guidance provides reassurance that a range of relationships that are important to a child have more chance of being supported. In that context, I also welcome moves made in relation to maintaining, where appropriate, sibling contact and strengthening the Grandparents' Charter. And on expanding support for ADR, the regulation of child contact centres and other provisions, the bill moves us in the right direction. It's been a collaborative process, but of course there have been areas of disagreement too. My amendment limiting the preparation of welfare reports to registered social workers excited some controversy, never necessarily a bad thing. It may have been a move too far for most, but it was good to have had a chance to debate this. I also acknowledge the bill's aim of drawing on a wider pool of skills and expertise going forward. On the question of a presumption of shared parenting, again, I recognise the opposition to such a move. However, this is an issue I think Parliament will have to return to in due course. For now, I thank those who have been involved in this scrutiny and look forward and confirm Scottish Liberal Democrats will be voting for the bill this evening. Thank you.
We now move to the open debate, and I call Rhona Mackay for up to 3 minutes, please.
Thank you, Presiding Officer. This bill is about giving children a voice, and I'm very happy to have been involved in working on what I believe is an excellent, much-needed bill. As Deputy Convener of the Justice Committee, can I thank the Clerks, Bill team, excellent witnesses and third sector organisations that helped us get it into the good shape it's finally in. Can I also thank Minister Ash Denham for all her work on the bill and for working with people across the chamber. I know from the outset that she put her heart and soul into getting it right. And at this stage, can also thank the former convener of the Justice Committee, Margaret Mitchell, for all the work she put into this hugely important bill. I can confidently say that all the amendments put forward at stage 2 and 3 from right across the chamber, whether ultimately passed or not, were submitted with good intention and with the best interests of children at their core. A widely supported aspect is the removal of the existing presumption in the 1995 Act that only a child aged 12 or over is capable of forming a view. The removal of that presumption in this bill is precisely what gives children a voice in a justice system designed for and by adults. For years, adults have underestimated the ability of children to express their view and for their voices to be valid and for them to be listened to. I'm delighted that this has finally come to an end with this bill. I'm also very pleased about the regulation of contact centres. One of the most memorable parts of our journey getting this bill to stage 3 was the evidence the committee heard in private from young people from Yellow, an expert group advising the Improving Justice in Child Contact project. And they had experience of being ordered to attend these centres, and their accounts were very powerful and moving. One by one, we heard of their traumatic and unhappy experiences of court-ordered contact, where they felt powerless to express what they really wanted. I was in awe of their bravery to tell their stories to a room full of adults. They've helped to shape this bill so that future generations will not have to endure their experience. Presiding Officer, sibling contact is vital and entirely in line with the recommendations in the Care Review, so I'm delighted amendments relating to that were passed. A huge part of this bill deals with statutory factors relating to risk and abuse. As ever, I think it's important to recognise the enormous contribution third sector organisations such as Scottish Women's Aid, Children First, the Children and Young People's Commissioner, and many others have had on shaping this bill. These professionals are at the front edge of child protection and welfare, and their input is vital and invaluable. Theorising is fine, but there's no substitute for the daily experience of protecting and making lives better for children and young people. If this bill helps to do that, then I think we should all be proud to pass it at decision time today.
Thank you. We now move to the closing speeches. James Kelly for up to 3 minutes, please.
Thank you, Deputy Presiding Officer. I'd like to make 3 points and sum it up. Liam Kerr, in his opening speech, pointed to the strong interaction that had been around the bill, and I want to place on record my thanks to the stakeholders, all the witnesses, to the Justice Committee, the Government Minister and all the MSPs who played an important part in the process, which I believe has resulted in a good piece of work in terms of legislation which is going to be passed shortly by the Parliament, and I think that will be welcomed by all. The second point I would like to make is the Minister herself said that this in effect is only the start of the process, the legislation being passed. The real test is to now see that all the good speeches, the good amendments come good in practice. There's an important role to be played in terms of guidance, ensuring that that guidance is strong enough, and we'll also have to monitor it closely, looking at issues like how children interact with the court, the experience of children in contact centres, and whether some of the issues that come up in evidence in the chamber have been addressed, and also the register of child welfare reporters and whether that reporting process improves in terms of better responding to the needs of children that come forward to it. So I think that is important. The final point I want to make is just about this debate there's been about bringing amendments at stage 3 in relation to John Finney's amendment. Of course, it's best for the parliamentary process if people bring amendments and suggestions as early as possible. However, we're failing in our duty as parliamentarians if someone brings a substantial issue at stage 3 and we simply don't want to engage or don't want to vote for it on the basis that it's come late in the process. I think the reality is that the government obviously have a substantial number of MSPs, and to get any amendment through, if it's coming from an opposition party, requires the support of all opposition parties. And I think that's a strong safeguard to ensure that any amendment is passed is not a lax one. So I absolutely accept that people should bring amendments earlier in the process for scrutiny, but if there's a gap which John Finney identified at stage 3 and other stakeholders identified, then we should address that gap. But in summing up, this is a good piece of legislation, but as the Minister herself says, this is only the start of the journey. Let's hope that this is a platform to serve the interests of children better in Scotland.
Margaret Mitchell, please, for up to 4 minutes.
Thank you, Deputy Presiding Officer. I begin by thanking all those who took the time to give evidence on the Children's Scotland Bill, and I pay tribute to the Justice Clerks and Broadcasting for their hard work, which enabled members to agree the Stage 1 report to dispose of the Stage 2 amendments virtually. Can I also thank the clerks for the support and assistance, and that's all the clerks I've worked with over the last 4 years, and wish Adam Tompkins well in his new role. The bill focuses, amongst other issues, on one of the most contentious aspects of family law, namely agreeing contact arrangements for the children when parents decide to live apart and separation is not amicable. Here, the children and young people are often the innocent bystander suffering collateral damage and frequently hopelessly conflicted. I fear, therefore, that the discussion with key stakeholders and the wider public debate during the scrutiny process may end up being acrimonious. The opposite has proved to be the case. And why? Well, quite simply, because the bill concentrates on the interests of children and young people and, crucially, ensures their voice is heard. Furthermore, during the scrutiny process, the bill has been improved with the removal of age limits for a child to be deemed mature enough to give a view, with the strengthening of the voice of the child provisions to make clear that children and young people must be able to express their views in the manner they prefer. And Section 16 investigations into a breach of court orders now explicitly requiring child's views to be sought. And also vital confidentiality provisions to avoid young people's trust being undermined now ensure that the best interests of the child must be primary consideration when considering disclosure of information, for example, of young people's diaries. However, it must be stressed that legislation alone will not ensure the voice of the child or young people is heard, or that contact centres will be able to continue to play their vital role without adequate allocation of resources. Turning now to the alternate dispute resolution amendments, as a result of these, the bill now provides for a viable mechanism to fund a pilot scheme to raise awareness about mediation as a possible alternative to court action. And mediation and early resolution helps prevent views becoming entrenched and reduces trauma. More than that, in the midst of a dispute about contact, young people frequently, irrationally, sometimes blame themselves, believing that somehow they've contributed to the breakup of the family. And through mediation, these feelings and other misunderstandings can be addressed. The amendments passed confirm on the face of the bill that the child's voice will be heard and bespoke family-focused solutions to parenting disputes put in place. But merely signposting people to where they can find out more about mediation will not be sufficient to encourage parents to even explore the option. It was for this reason the committee unanimously agreed mandatory mediation information meetings should be piloted, with the exception for domestic abuse. Finally, Presiding Officer, together, the Children's Scotland Bill represents a significant step in ensuring that children and young people's well-being are at the centre of proceedings that concern their future when parents separate, and the Scottish Conservatives will have much pleasure in voting in favour of it this evening.
I would ask Ash Denham to respond to the debate for up to 5 minutes, please, to decision time, Minister.
Thank you, Presiding Officer. And I'd like to begin by thanking members who have contributed to the debate on the bill this evening. And I'd also like to take this opportunity to put on record my thanks to the bill team for their hard work and their unstinting support of me during this period as we developed this bill. The debate this afternoon shows, I think, that improving the family courts remains an important issue for a number of members, and I hope that this bill will be the starting process for these improvements. And I'll just address a few of the comments that were made this afternoon. So on the issue of evidence, Liam Kerr, as well as a number of members, noted the quality of the evidence that came forward from those who had lived experience and how that has shaped what has ended up on the face of the bill. An example of that was around contact centres, domestic abuse, and also Liam MacArthur's amendments around confidentiality of information. And my view is that is how it should be. That is how it should be. And I also note and thank Liam Kerr for his comments on the collaborative nature of the process. John Finney spoke about the voice of the child. He said, the voice of the child will now be listened to differently. And he also noted the pivotal nature of the regulation of child welfare reporters brought to life by the evidence to the committee that he cited of a child who said, that's not what I said, on what had appeared in a child welfare report. So I agree on the pivotal nature of that step forward. Rona Mackay also mentioned the voice of the child in her contribution, with her comment that this bill gives children a voice in a justice system designed for adults. James Kelly spoke about child contact centres and how welcome the regulation of child contact centres would be, ensuring the safety of children attending, and that, in his words, it was an important piece of legislation. And I agree with him wholeheartedly on that. Rona Mackay noted the young people who gave evidence to the committee on their experiences of child contact and how that has shaped what has ultimately ended up in the legislation. So I worked hard to incorporate suggestions on how to improve the bill from the committee, from external stakeholders, and I've also worked with members right across the chamber, wherever I could, on areas that were of concern to them. The policy that underpins a bill is a bit like a snapshot of a moment in time. You know what you want it to look like, and you just line it up as best as you can. I know this is not the end of the road for family law, but it is a step forward, and it's a significant one at that. The bill puts the children's views at the centre, and they can give their views in a manner that they prefer. And then important decisions about what is happening to them will be communicated to them in child-friendly language. The bill also includes measures to deliver proper participation to brothers and sisters in children's hearings cases. Victims of domestic abuse will be further protected, as those convicted of domestic abuse will now be prohibited from representing themselves in court. Child welfare reporters will have to meet standards of training and experience. Contact centres, for the first time, will be regulated and will have to meet minimum standards of accommodation and staff training. With the child at the centre, this bill allows a child's voice to be heard at a key moment, at a time in their life where their life may have just been turned upside down, where they're worried about what's going to happen to them in the future. So it's very important that we listen to what they have to say. When I met with children who had gone through the family court system, one girl said to me memorably, "No one is listening to me." So this evening, I can say to her and to all the children in Scotland that are going through the family courts at the moment or in the future, I listened, the Scottish Government listened, and the Parliament has listened.
Thank you very much, colleagues. That concludes our debate on the Children's Scotland Bill. Now, we're going to come shortly to a vote on the bill itself. Could I ask all members, if they haven't already done so, to open their voting app and to make sure they've refreshed the page. And we're not going to vote just yet, but just if we do so now, hopefully when we come to the vote, we'll be ready. So you should open it and you should see no vote currently open. Now, the next item of business is consideration of Parliamentary Bureau Motion 22528 on approval of an SSI. Could I ask Graham Day on behalf of the Parliamentary Bureau to move this motion?
Move, Presiding Officer.
Thank you very much, Minister. So we're turning now to decision time. So hopefully members will have opened their app. Just patience, Mr. Halker-Johnson. So before we come to the vote, make sure that everybody's opened the voting app. Is anybody here still waiting for their page? It should say no vote currently open. If anyone's not got that page, could they raise their hand? And we'll get... Excellent. I'm hoping online it's all working. So, the first question this evening is that motion 22505 in the name of Ash Denham on the Children's Scotland Bill be agreed. Are we all agreed? Yes. We're going to move to a vote. This is an act, so we're going to move to a vote. So I can ask members to cast their votes now, and this will be a 1-minute division. Members may vote now. Yes, members, raise their hand if it's not opened. Yes.
She couldn't do hers earlier, so that...
The result of the vote on motion 22505 in the name of Ash Denham is yes 113. There were no votes against, there were no abstentions. The motion is agreed and the Children's Scotland Bill is passed. Thank you. Our final question is that motion 22528 in the name of Graham Day on approval of an SSI be agreed. Are we all agreed? Yes. We are agreed. That concludes decision time and I close this meeting.